Please, Your Lordship. Lord, beg to mention, Lord, with regard to item number 30, one additional affidavit was filed, my lord. That
Yes.
is not on record.
Brought on record?
Yes. Oblige me.
No problem.
Mr. Sasi, but I beg to mention item number 50, Your Lordship.
50.
50, Your Lordship.
Hearing matter.
There is a fixed for hearing. The joint prayer, Your Lordship, if it can be on the second week of January, Your Lordship. 8, Your Lordship is fixed.
For the other side.
Yes, Your Lordship.
And comes pray for prayer is allowed. Oh, 25 matter. Second week of January might be closed, I think.
On
You
8th is Your Lordship
So I
possible. On 6th or 8th.
Should I fix it after BU vacation? Is it okay, or you want it
Preferably, if we'll try our luck or also on 8th, it was
8-1?
Lordship.
Obliged, Lordship.
May I please, Your Lordship. Lordship, I beg to matter for listing a unlisted matter for BA, my lord. For today, my lord. I am obliged, my lord.
Time permits.
Please, Your Lordship.
Yeah. Laminate for it? Yes, tell me.
Lordship, I beg to mention item number 44, Your Lordship.
44. Yes.
Lordship, there is some personal difficulty, Your Lordship. I pray that the matter may be taken up after vacation, Your Lordship.
Yes. Adjourn for the day. List in the month of January on a date to be fixed by the registrar.
Lordship,
Let
if
them
a
fix
date
it.
is kindly given, Your Lordship,
Date, let them fix. If it does not get listed, you make a mention.
deeply obliged.
Think-
Lordship, there is another prayer, Your Lordship. I beg to mention for listing of a regular bail application, Your Lordship, for tomorrow.
Tomorrow, there's some time constraint, but it's okay.
Deeply obliged.
May it please, Your Lordship. I beg to mention item number 28. The matter kindly may be adjourned for today due to some personal difficulty of the senior advocate. 28.
Interim is there.
Interim is there. Any day next week.
Case diary has been received.
Please, has been received, Lordship.
Received. Tuesday,
Next week.
interim extended till the next date. Case diary be retained, list on 16.
Deeply obliged.
May I please, Your Lordship. Lordship, item number 40, kindly fix at 2 p.m.
2 p.m. another matter is fixed.
40.
actually. So we'll see.
Oblige. May I, Your Lordship. Your Lordship, I beg to state that item number 2, out of same affair, 2 other bail petitions have been has been listed on 18 December for case diary.
Okay.
I request Your Lordship to tag my case with it.
List the matter on 18, 12, 25 along with BA number. You have the number.
Yes, I have the number, Your Lordship.
Kindly give the number.
Item number 2.
3927
One will do along with.
and 3971.
Please, Your Lordship. Lordship, in 28, interim may continue. I just
Where? I have
deeply obliged.
I have mentioned. Just a minute, just I'll cross check. Interim, yeah, we have written.
Deeply obliged.
May I please, Your Lordship.
Yes.
Lordship, I beg to mention item number 34, Lordship. Lordship,
34?
CD was called for that has not been received, Lordship. We are in interim, Lordship.
34 CD not.
Issue reminder for the city. Interim extended till the next day. List the matter. When? After?
My lord, interim is there, my lord.
Yes, I have extended that.
My lord, 22-1, my lord.
Oblige me.
Lordship. Lordship, actually, matter may be fixed of a bail hearing column, Lordship. It's wrongly listed in motion columm.
Bail
CD
hearing.
also,
Wrong.
No, my lord.
No motion.
CD also receiving office, Lordship,
But you can take up the press.
or something.
After something
So we have to verify whether you received only tomorrow, my lord.
tomorrow.
Tomorrow, my lord.
Will come in.
So tomorrow in the bail hearing column, my lord.
Bail hearing column.
Bail hearing.
List the matter and CD has already been called for in this case. Therefore, list in the column of bail hearing on tomorrow,
Obliged.
12.
My lord, with all respect, my lord, 3 and 4
Hmm.
pertaining to the same PS case, my lord. Can it be on 18th, my lord, with all respect, my lord? Case diary, my lord.
18th,
My lord. Oh, one before the last day.
case diary,
Case diary.
call for the case diary of Dispur PS case number
875-25, my lord.
Dispur PS case number 875 of 2023. The petitioner was arrested on both dates, same
But same.
27/10/2025. List on 18/12/2023.
Highly obliged, my lord. Obliged.
Order.
Obliged.
Or also same order.
Perhaps Lordship will remember this matter, my lord. One officer in charge of a police station, my lord.
Uh-huh.
He was arrested on the allegation that
Also
there was a custodial death, my lord. The Lordship had earlier rejected it.
rejected. So,
Yes. So, my lord, case diary, my lord, any day next week, my lord, 65 days already, my lord.
Statutory period is over.
90 days.
It's anyway. So
Any date, my lord, next week. Possible.
the as thus heard concerned, who fairly submits that earlier bail petition was rejected by this court on 25/11/25 in BA 3675 of 2025. Call for the updated case diary. List the matter on
18 mile.
18. 18. Okay.
My lord, CD along with PM report and
CD along with PM report and
FSL.
FS if available. 18 is okay. 18
It
is
will
okay.
be last day, perhaps, my lord.
No, 19 is
19
last.
19.
Second last day.
Highly
Will be 18/12.
May it please your lordship.
Tell me.
Lordship, in case number 22, notice 47, lordship. The allegation, lordship. The detailed grounds of arrest from last portion fifth line. lordship. You are found involved with the offense. You are directly in contact with Abdul Quddus, who is the receiver of the stolen items regarding the case. In presence of police, you help Abdul Quddus to escape from place. Your interrogation regarding this case is much necessary. The case is non-bailable in nature. Notice under section 35(2) could not be served up because you will hamper investigation of the case if you are not arrested. Lordship, the punishment in this case, the below 7 years, lordship, but the notice not been served under section 35(2), lordship, which is
Notice can be
mandatory.
waived, but the reasons have to be given, right? As you know. So let's,
Lordship.
before the vacation, I will fix it. Call for the case.
Lordship, and lordship
Not Guwahati.
on submission, lordship.
Yes, sure.
Lordship, I'm lordship 18 years old, lordship, and I'm reading in class 11, lordship. And also I have to study, lordship. Interim bail may be granted, lordship, and another lordship, and another is arrest memo, lordship. Arrest memo in phase 24, lordship. The signature of at least one witness is necessary, lordship, which is mandatory in nature, who is also not taken in this arrest memo, lordship. And in this case, lordship, for the supporting, lordship, I am providing judgment DK Basu case, lordship. I have highlighted the para, lordship.
That's true. I'll keep this.
I'm only 18 years old, lordship. Only interim.
Can
Well, maybe.
it's a case of theft or Monday? Can you not Guwahati?
Not Monday, my lord.
Tuesday? Tuesday, get it.
Tuesday, my lord.
heard so and so. Call for the case diary of North Guwahati PS case number 111/2020 under so and so. The accused, stated to be aged 18 years, was arrested on 4/12/2025. The learned counsel praying for interim bail submits that he is a student and that there is infirmity in he was and that he was not given notice under section 553 PNSS, and also that the arrest memo suffers from procedural deficiency in terms of the law laid down by the Honorable Supreme. However, at this stage, I deem it fit only to call for the case diary. I'll list the matter on 16th. I'll keep it for the moment. I'll give it back to you on the next. On Tuesday.
Obliged.
Wait, please, Your Lordship. In the 453 application, Your Lordship, the petitioner was arrested on 2/12. Now, this case, Your Lordship, basically we are challenging on the grounds that section 48 has not been complied with. Basically, not on the merits, basically on this fact that the section has not been complied. Your Lordship will find the notice that Your Lordship will find the notice at page starts
Yeah,
from,
I found 18. Page 18, right?
yes, yes. So these are the notices given. Now, Your Lordship will see two things very clearly. The notice has been given. There are 4 accused persons here. We are coming for one only. The notice has been given to only one person, the name, Rabbul Islam. Then secondly, that notice is received by another person, which is Rafiqul Islam. That Your Lordship will see the name. And this particular person, either Rabbul and Rafiqul, are neither his relative nor his friend, neither family member. So therefore, these services
Any nominated person, it can be given.
is
to
not,
anyway.
he is also not a nominated.
So
And
anyway,
in fact, Your Lordship will see
note
the
this.
next page, 20. In page 20 also, this is sent to another, with regard to another person. That is also Rabbul Islam, received by Rafiqul Islam. Then the third one at page 22, same person. And at page 24, the same person. So therefore, this particular while there is a specific allegation of
Deficiency.
violation of,
according to you, this is deficient. This is deficient according to you.
yes, that is what I'm trying to point out, which is Your Lordship knows, it is violative of Article 20.
Hathigaon PS. Can you get it on Monday? Monday? Can you get it? Huh? Try it on Monday or not be possible? Monday? Get it on Monday.
Monday.
Call for the case diary of Hathigaon PS 209 of 25. Arrested on 2/12/2025. Mr. Manan, learned counsel for the petitioner, drawing attention to the notices under section 48, submits that the same suffers from deficiencies violative of the law laid down by the Honorable Supreme Court. Like this,
Yes.
This is the matter on 15th.
If you want.
May I please, Your Lordship, my lord? Can you take it after some time, my lord? Obliged.
Last paper.
Please, Your Lordship.
But this is an anticipatory bail application, my lord. The FIR, my lord, is that starts from page number 14 and the vernacular is at page number 19. Basically, my lord, there is a dispute between two sides, my lord, regarding, my lord, cultivation over a plot of land. We were saying that it is our land, and the other side says that no, that is their land and they want to cultivate. So on 9/11/2025, there was some kind of altercation where members of both the sides receive injuries. Now the FIR, my lord, was registered under several sections, my lord, 61, 109, 117, 118, and 304, pertaining to, my lord, attempt to murder and grievous hurt. On, my lord, day before yesterday, one bail application was considered by your lordship. There, my lord, bail was granted, and the medical report was considered by this court, wherein it was revealed that the injuries were simple in nature.
RJ product. Wildlife, I think we wrongly read
Yes, yes.
wildlife. This but is arising out of the same case, right?
Same case,
Majnu Hawk.
Majnu Hawk.
Majnu Hawk is number 3. no? Today, the others are here.
Yes.
Other 8 are here.
Para number 5.
Yeah, when was it disposed of? 8.
It was disposed of on
Diary
8/12.
here.
My lord, maybe here, my lord. So, my
Check
lord, we take instruction and my lord take the diary then
Today itself.
itself or my lord tomorrow, any day.
You can just find out.
My lord,
Tomorrow there will be some time.
my lord, today,
There's a
if
reference.
it is available, my
My
lord,
lord,
we
yes.
just send instruction, my lord.
No,
We will take it.
we'll hold it.
My lord, then at 2, my lord.
Whatever it's too, it's a matter also. Anyway,
My,
just find out whenever
Fine.
you get the information.
my,
Otherwise, we'll fix it tomorrow.
Highly await.
Student can be considered. It works.
Wait, please, my lord.
9.
Wait, please, my
Tell me.
anticipatory bail application, my lord. My lord, our names do not appear in the FIR, my lord.
Mhm.
My lord, may kindly have page 13 for a moment, my lord. May I read, my lord?
Yes, please go ahead.
To the officer in charge, with due respect and humble submission, I beg to state that on 29/25 at around 1:30 p.m., I came home from the grocery shop and parked my bicycle in front of the gate. When I got off my bicycle, 8 to 10 strangers from 2 vehicles grabbed me and tried to force me into the car. When I refused to get in the car, the above men slapped me on various parts of my body. They also kicked me in the leg, forced me and dragged me in the car, took me to various places of Tezpur, and then took me in a deserted place in the mountains and called me to my home by my mobile phone and demanded money. When I say I don't have money at home, he asked my wife for rupees 70,000. My brother asked them where the money should be handed over, and they told to come to Ganesh Ghat. Therefore, my brother Muhammad Usman Ali handed over the money to one unknown person at Ganesh Ghat. The strangers took the money and got into the car wide this vehicle number and left. The video footage of the payment is on Usman Ali's mobile phone. My lord, there is a name of the accused also, my lord. Muhammad Musarraf, my lord.
Right.
Our name is not that, my lord. We are Manos Mes and Parvati Rabha, my lord. Moreover, my lord, the applicant number 1, Manos Mes, my lord, he has been undergoing medical treatment throughout the month. What happened is, my lord, on that day, my lord, of the incident, my lord, 20/09/2025, they were actually going for a medical treatment, my lord,
Mm.
towards, my lord, Porwa area of Tezpur.
Mm.
There, my lord, they saw a crowd, my lord. My lord knows, my lord, in these small towns, my lord, relatively small towns, my lord, people, when they see someone, there's a huge crowd, they usually ask what is going on. Upon asking, they were informed that the person who has been apprehended, the complainant, he's a drug peddler. They just asked that, heard that, and they left for their visit to the doctor. That is our case, my lord. We are not involved in this case. If my lord would kindly have page 20 onwards, my lord, kindly. 20, my lord. My lord, throughout this incident had occurred in the month of September, my lord. Throughout the month of September, my lord, annexure 2, 3, 4, 5, we have been taking medical treatment, my lord. In fact, my
Just a
lord,
minute. It was
Yes.
FIR is dated 29.
29.
The same day it was not.
Same. And my lord would kindly have annexure 2 onwards, my lord. Page 20, my lord.
Umar Ali is the informant.
Yes, Umar Ali is the informant. We don't know him. Only on that day, my lord, by stroke of bad luck, my lord, why we had asked them, it happens in these small places, my lord, mostly. What is going on? This kind of a question we had asked, and that is why, my lord, we also thinking because those names are not clear in the FIR, the apprehending arrest and police has been coming. Our names are also not there, my lord. Honorable Apex Court has also laid down, my lord.
Sir,
Prima facie, the FIR has to make out the case.
anyway,
Police is coming and searching for us, my lord. In fact, my lord, we have my disease, my lord, the applicant number 1. It's so, my lord,
yeah, police
serious, my
must have found, may have found some materials.
My
Which is
lord.
why they are seeking you out. Anyway,
Short date, my lord, short date.
My lord, interim may be given till then, my lord. Interim may be given.
Because
We
of the,
will
my lord,
go, we'll record our statement if need be. Interim may kindly be
because
given.
of the
my lord.
nature of offense, my lord. Otherwise, not, my lord.
Yes.
In these cases, my lord, it's not possible that everybody's name will come out. And my lord, in the FIR, the stranger word is also there. So, my lord, very short date, my lord, 18/12, my lord.
My lord,
So still
wait,
Tuesday?
wait,
Tuesday? Not possible.
Tuesday also, my lord. We can try for Tuesday also.
Or 17.
17, man.
My lord,
17, man.
my lord,
17, man.
my lord,
Should
interim
he
may
record his statement in the meantime?
yes, my
Yes, I think you can record his statement, but 17, try to get the case back.
My lord. Then, my lord, if my lord was pleased to grant him interim, then after vacation,
No, because we don't know. There may be materials.
my lord.
There may be materials
Yes,
which will
then,
not,
my lord, yes.
will not justify anticipatory.
Yes, my lord. Because, my lord, because of the nature of
Because he has
application.
made a contention.
Yes, my lord.
I have trusted.
My lord.
My duty.
My lord.
So, but suppose he is one of the persons in
Yes,
the network,
Yes, my lord.
then it will not.
Yes, my lord.
That is why
Yes,
17.
yes,
I was telling, na, long
yes,
dates.
yes,
We do not know.
yes, my lord.
Anyway, because yes, we are constrained next week, no doubt about it.
Yes, my lord.
But we'll try.
Yes,
You said 18.
18. 18.
You record his statement. Wishes. That option should be given.
We can, my lord, try for 17 also, not any.
Hmm?
Because 18 is, my lord, more. 17.
Heard, your good name, please.
PR Sarma.
Learned counsel for the petition. The invoking 482. The petitioner is seeking anticipatory bail in connection with Tezpur PS case number 646/25 under so intersection. The case arose out of an FIR Ezahar dated 20/9/2025 caused by one Umar Ali with the allegation and that that on that day in the afternoon when he was coming from his uncle's grocery shop and got off his bicycle on the way, 8 to 10 strangers from 2 vehicles grabbed him and tried to force him into the car. And thereafter took him to a deserted place and demanded rupees 50,000 by making him call his home. And subsequently, his brother, the informant, and subsequently, the informant's brother handed over the money to some unknown person at another place. The sole name they used is MD Musarraf. The praying for interim bail and desire to record the statement, the learned petitioner counsel submits that the petitioner is not named in the FIR and that he is a victim of circumstances in as much as on that day while he was going to Tezpur for some medical treatment on he saw a crowd on the way and asked regarding the same, whereupon he was told that the informant Umar Ali was a drug peddler and as such the crowd had confronted him. Call for the case diary from the concerned police station. However, with a view to enable the petitioner to record his version of events, it is directed that in the interim 25,000 with one security to the satisfaction of the concerned learned CJM, sorry, to the the satisfaction of the arresting authority and subject to the conditions that he shall cooperate investigation, he'll appear before the IO, making himself available for examination, shall not hamper or tamper with evidence. This is the matter on 17th.
Well, 17.
My lord. Well, it's with they will, my lord, two applicants.
Hmm?
My lord, subject to corrections. My lord has stated just he, my lord. It should be they, my lord, two applicants. Both of them.
Oh, two applicants.
Two.
Manoj Smash. We don't know at this stage. But they were going.
They.
17th, right? Mr. Bosha?
18th, no, it is recorded.
17th or 18th?
18. I'm so obliged, my lord.
Yeah, please, Your Lord. Lord, admittedly in this case, my Lord, the diary will be necessary, my Lord, but at the same time, my Lord, we would humbly pray for the interim protection. And why I'm saying so, my Lord, because Lordship is pleased to peruse the facts as reflected in Annexure 1, that is page number 13.
Page number 8.
13, 1-3, my Lord. 1-3. So the case could arise, my Lord, on account of dispute between the parties, my Lord, over their ancestral land bill. And in fact, my Lord, title suit is also going on and other several civil proceedings are there, my Lord. So on account of that, my Lord, the incident happened. And that, my Lord, admittedly, there was an altercation, my Lord. And since, my Lord, that the altercation was there and that, my Lord, the injuries occurred to both the parties, two cases were registered, my Lord, one filed by the present informant, my Lord, and the another filed by our side, my Lord. So both have been registered. So Annexure 1, that is the, my Lord, FIR, we are seeking bail in respect of, my Lord, Nagarbara PS case number 74. So may I read, my Lord?
No, you read this FIR,
My Lord, yes.
which is lodged against you.
Yes, my Lord.
13.
Page number 13 onward, that
14.
relevant portion, my Lord, page number 14.
Respectful submission.
Respectful submission is that today dated 30/10/2025 at about 7 a.m. while we three brothers were working with our father upon a plot of land under our possession, the aforesaid accused persons rendered repeated blow upon the head and other parts of the body of my two brothers and my father with a dao, axe, dagger, lathis, and other sharp weapons with an intent to kill them and seriously injured them, consequent whereupon the head of my father and two brothers, namely so and so, split and I sustained head injury. Abdul Matlab snatched, that is the petition number 2, my Lord. Abdul Matlab snatched away the gold chain from the neck of my elder brother. Although the injured were rushed to the Nagarbara PHC, but since the assault and injuries were serious and bleeding of my father and two brothers did not stop, all the three were referred to GMCH. At present, they are undergoing treatment in the hospital. It is worth mentioning herein that accused number 2, 8, 9, and 10 came in front of our house and threatened that tomorrow they would demolish our house and boundary wall by some hired goons, and accused number 2 demolished one of the wall of our newly constructed house while we were undergoing treatment at Nagarbara Hospital, and threatened to kill the female members of the family if they come out from the house. Therefore, you are requested to investigate into the case and take proper action against them. This is the affair against us, my Lord. Now, if your Lordship is pleased to peruse Annexure 2, my Lord. Annexure 2, that is page number 20. This is the, my Lord, FIR lodged by the wife of the, my Lord, sister-in-law of the petitioners, my Lord. May I read, my Lord? Respectful submission is that in the morning of last 30, the date of occurrence is the same, my Lord. In the morning of last 30/10/2025, accused number 1 instigated his own brothers and being armed with dagger, jung, lathis, etc., the aforesaid accused persons demolished the newly constructed house of our family even before we woke up from the bed. While our family members resisted as per the direction of accused number 1, all the accused persons started assaulting our family members, and one of my brother-in-law fell unconscious while accused number 1 stabbed him at his belly with a dagger. After hearing the hue and cry, while 4 members of our family went ahead, accused number 1 again rendered blow upon the head of my husband and nephew with a dagger, who also fell unconscious, and they fled therefrom. That, sir, accused number 1 is conspiring to our family in a pre-planned manner since long. Moreover, on several occasions, he has threatened to kill the family members and my husband. That, sir, the accused number 1 is a lawyer by profession. Since many days, he has been persevering to forcefully grab half of our ancestral properties, that land and residence, by means of threat and intimidation. He is also resisting the mutation of our ancestral land by threatening in various ways. That, sir, as per direction of the accused number 1, the other accused persons are harassing us financially, mentally, and physically since almost last 5 years. All we are dependent upon daily labor and agriculture. As he is a lawyer, he very often openly threatens us as at gunpoint in broad daylight. My brother, nephew, and my husband are fighting for life in ICU after being admitted at GMCH in a critical condition. At the same time, they have also threatened that they would diminish us overnight by some hired gundas. Yesterday, the whole family had been at the hospital, and we were was weak physically and mentally, and my husband was admitted at GMCH along with my brother-in-law. Today, after my son went to GMCH, I have directly come to police station and have lodged this FIR. So this is the FIR given by our side, my lord, and the case registered, if your lordship is pleased to peruse the sections, that is, my lord, 118 subsection 2, 109, that is attempt to murder, my lord, and then other, my lord, the assault and injury and the conspiracy, etc. So all these sections registered in both the cases, my lord, are identical. And only the difference is that, my lord, in our case, my lord, the case lodged by us, the section 109 is there, which is not in the case in respect of which we are seeking bail, my lord. And that, my lord, we are undergoing treatment, my lord. Your lordship will find the medical reports, my lord. That would see that more than 13 days we were at hospital at page number 30, my lord, annexure 4. I'm extremely sorry that, my lord, the type copy is not given here. I'm sorry for that. But here it is. If your lordship is pleased to peruse the my lord, the details, admitted on, my lord, 30/10/2025, that is the date of the incident, my lord. Then, my lord, hospital number so and so, MRD number so and so, name it, this is Abul Kashem. So he is accused in this case. And then the next medical slip, your lordship will find that at page number 31, my lord, that is also the petition number 2. He was also admitted in hospital. He had also undergone treatment at Namcare Hospital, my lord. So considering his serious condition, they were under treatment. Then the next page is, my lord, that the medical report of one Farooq Abdullah, that is the nephew. So all these things have been especially mentioned in our, my lord, FIR also, and that we sustained injury, that was grievous, my lord, and that, my lord,
Both sides sustain injury.
My lord.
Both sides.
so now for your lordship perusal, my lord, I would take your lordship to page number 33. Page number 33, annexure 5, my lord. So this is the case that they sought for bail, my lord, in respect of the, my lord, FIR lodged by our side. Honorable Sessions Judge Amin Gao was pleased to, my lord, grant them anticipated bail, in fact, imposing some condition, my lord. So that, my lord, in their case, that is in this case, my lord, all the accused persons we have mentioned in our FIR, Samsul Haq, Altaf Hussain, Shahinur Alam, Abdul Malek, Airul Haq, all are the accused person in our FIR, my lord. So they have been granted bail, my lord. And that is Zakir Hussain, that is accused number 1 in our case, he has also been granted bail. So, my lord, in this case, at this moment, except, my lord, section 118, as the registered, my lord, incorporated in our, my lord, against us, my lord, other sections are punishable, my lord, up to 3 years, my lord. So your lordship may be pleased to call for the case date at the same time that they have already been granted with bail, my lord. On that ground of, my lord, parity, that we may be also granted with interim protection, will appear before the IO, record our statement, my lord, and in the meantime, diary may be confirmed.
Heard so and so. Yeah.
My lord, both are FIR and accused, my lord, and my lord, that is the relevant part, my lord, is that, my lord, পদকীয়াগণে মোৰ লগত মোৰ দুজন ভাই আৰু দেউতাক দা কুঠাৰ ডেগাৰ লাঠি আৰু বিভিন্ন চোকা অস্ত্ৰৰে প্ৰাণে মৰাৰ উদ্দেশ্যে উপৰ্যুপৰি মূৰত আৰু শৰীৰৰ বিভিন্ন অংগত আঘাত কৰে।
We have
So,
also
my lord, at
admitted,
this
but
stage, my lord, CD may be called for pre-arrest bail application, my lord.
that
The
they have been
petition of
granted.
CD is required, my lord.
The call for the base diary of
Nagarwala PS case number 74.
Nagarveda base case number 74 of 2025.
My lord.
13 accused persons are named in the fire. The learned counsel for the petitioner praying for interim bail submits that there was a marpit with another group of persons, and the petitioners herein also sustained serious injuries. And yes, it is submitted that the petitioners, the persons who had assaulted members of the petitioner's family have been granted anticipatory bail by the learned additional sessions as Kamrup Family. I've given my consideration to the matter. However, considering the serious nature of the allegations and the serious nature of the injuries indicated, including head injury, prayer for interim, I'm not inclined to grant interim at this stage. Call for the case diary along with the medical report.
Yes.
My lord, may I pray that, my lord, case diary of both the cases may kindly be called for and injury report, my lord.
Both the cases.
My lord, 74 and 75.
Cross case is different for the purpose of bail. Let it be.
My lord,
When
then
date,
মানে উঠে গেছে মনে হয় agriculture এর খেতিবাড়ি 15 ও তৃতীয় খায় নগরবাড়ি পিএস মিনট
Difficult, man. Then
May I suggest-
17 might. 7.
oblige me
board
Category 11.
chart on the. Same.
Mate, please, your lordship. Lordship, chart sheeted matter at this stage, else TCR may be called for. Your lordship.
Charge sheet. POXO.
No, not POXO, PRC. PRC number 441/29.
Sections, what kind?
Sections 120B, 326, 302, 34 IPC, 2023 old case, your lord.
Okay, in that case, we can heard. Call for the scan record of PRC number 441 of 2025 within bracket arising out of Rupohiya TS case number 33 of 23. Under so and so section from the court of the learned CJM Nodo. The scan case record may comprise of the case diary, charge sheet, medical documents, and other relevant documents. That would do. This is the matter. Suggested it.
Scan TCR, man.
Scan.
Get my lordship's convenient. Because my lord, next week is motion day, man.
You want it next week or after vacation?
After vacation.
6.
6.
6.
Item 51.
I mean,
May I please, your lordship? My lord, with all respect, my lord, on the face of it, a dirty case, my lord. Because the reason, my lord, a judicial magistrate's car, my lord, dashed into a car of another car, my lord. With all respect, my lord. But, as we have been told, my lord, the identity of the judicial officers was not known to the inmates of the other car, my lord. And thereafter, the FIR, my lord, with all respect, my lord, is at page 16, my lord. If it is read in totality, my lord, of course, my lord, the learned magistrate, my lord, his part of the story should be correct, my lord. If he read it in totality, my lord, the offense under section 109 would never be made out. That is the only non-bailable offense, my lord. Despite the, my lord, with all respect, my lord,
109, this
allegations and counter allegations, my lord.
homicide.
Oh, both these. My lord, only one thing is apparent, my lord. Out of 3 accused persons, one accused, my lord, he is a, my lord, he read up to class 6, my lord. May your lordship read para 11, my lord, page 8, my lord. Then thereafter, I'll show the papers, my lord, 47, 48, my lord, and the latest authority, my lord. Para 8, my lord. Page 8, my lord. I'm sorry, my lord. Para 11, my lord. Leaving aside 5 lines from the top, my lord. Moreover, the accused petitioner number 2, I am paying only for 2, my lord. And his wife cannot understand English. The notices were served on his wife and him, my lord. However, they can only understand, read rudimentary Assamese, Gwalporia Dekhi Bhasha language, my lord. Now, my lord, coming to the notices served, my lord, straight away, my lord. My lord, 47 is at page 28, my lord. 47 is at page 28, my lord.
Mhm.
It is in English, my lord.
Mhm.
And he has taken, it is a thumb impression of the accused, my lord.
Mhm.
Out of 2 accused arrested, my lord, 1, my lord, it is by thumb impression. And thereafter, the notice under section 48, next page, my lord, page 29, served on his wife, my lord.
Mhm.
She has also accepted it by a thumb impression. My lord, as per the contents of page 8, para 11, my lord. And the authority latest is, my lord, that Kofiposa case, my lord, with all respect, my lord. Hit and run case, I'm sorry, my lord. Mihir Rajesh Shah versus State of Maharashtra, my lord. There, the, my lord, with all parameters have been fixed at para 56. May I just read it and place it before your lordships, my lord? Para 56, my lord, Roman 2, my lord. The grounds of arrest must be communicated in writing to the arrestee in the language he/she understands. Only regarding one, my lord, definitely.
Yeah, but that is arrested, is communicated in his own written, understandable language. They have written, still,
My lord,
ideally, it should be also written in his language.
my lord,
But Gwalparia is, it has to be in Assamese.
my lord.
Is it-
Possibly should have been Assamese, my lord. Only regarding one, my lord. Rest, no, and they have accepted notice, my lord. And the offenses also may not be 109, my lord, but in the face of it, my lord, behavioral attitude is not good, my lord. And that is for this page for only accused number 2, my lord.
Mm.
For the rest, definitely case diary, my lord. And 109 would not be complete, my lord.
Anyway. Only case diary at this stage.
My lord.
So, call for the case, heard learned consequence. So, we can call for the case diary of Bilasipara PS case number 376 of 25. For two accused persons seeking bail herein were arrested on 2/12/2025. Learned counsel drawing attention to the notice under 48 with regard to petitioner number 2 submits that the same was written in English language and conveyed to a person though she is incapable of understanding English. And that the same is violative of the law laid down in paragraph 56. Law laid down in Mihir Rajesh Shah versus State of Maharashtra 2025. Is that? However, at this stage, I am inclined to call for the case diary only. But give a date before vacation, Tuesday or something.
Bilasipara, my lord.
17,
It is.
he says that a lot of matters have been already.
My lord, 18, my lord.
Well, only one more line, my lord. That aspect would be also examined on
It's
that.
everything I'll examine.
My lord.
Everything I'll.
My lord. My lord.
18.
16.
My lord.
Please, Your Lordship. This is a regular bail application. Offense under section 21C, 25 and 29 of the NDPS Act. Your Lordship has already heard it to some extent, my lord. Take your Lordship to the FIR, which your Lordship will find at page 13. So here trial is going on, my lord, and 3 witnesses have been examined. 2 are on record, my lord. Another I have a certified copy, my lord.
What is the issue here?
The issue here, my lord, was that this 16 cartons of cough syrup were found, my lord. According to the prosecution,
I have any note. I had heard it. No?
my lord.
Note then.
My lord. Yeah.
Just a minute, huh?
Fine.
Yes.
The two drug, I'll just give the facts, my lord, briefly, my lord. Two drug peddlers were, my lord, alleged drug peddlers were caught by the police. On interrogation, they said they took the police to 3 different places
Mhm.
where police recovered cough syrup bottles. Now, one of the allegations in the FIR is that 16 cartons of cough syrup, my lord, codeine cough syrup containing 1600 bottles were found as per the prosecution in the front yard of my house, my lord.
No, yes.
So on that allegation, the case was registered.
In your house compound.
House compound. So during investigation, I was not arrested by the police. So police submitted a charge sheet against me, showing me as an absconder.
Acha.
Thereafter, my lord, on receipt of summons, I appeared before the trial court, pressed a bail application. Trial court did not, on count of the regards of 37, took me into custody, my lord. Subsequently, charges were framed, and till now, my lord, 3 witnesses have been examined. So, my lord, my contention before this honorable court is limited to this extent that nothing was recovered from my physical possession. So, for considering the rigors of 37, your lordship will examine whether there was conscious possession and whether there was exclusivity of possession. Because, my lord, first of all, my lord, the house where this contraband was found, whether that house belongs to me, they say that it belongs to me, but since it's a charge sheeted matter, all materials and all evidences have been collected by the police. So is there any evidence which my learned friend can point out before this honorable court that this house where this contraband was allegedly recovered belongs to me? Secondly, my lord, assuming their case that this house does indeed belong to me, I am not the sole resident of that house. And the yard of the house, my lord, that yard of the house is accessible to the other residents of the house, including neighbors and including other people, my lord. So
It was in the compound.
in the
It was in
compound,
the compound.
not inside my room, not inside my exclusive control, my lord. So when there is no exclusivity of possession, my lord, whether this recovery, alleged recovery, the conscious possession of this alleged recovery can be attributed to me, my lord. That is the whole issue here, my lord. So based on the materials which they have, because otherwise prosecution has examined 3 witnesses and all 3 have been declared hostile. One has not been declared hostile. 2 and 3 have been declared hostile. They have not supported the prosecution's case.
3 out of
3 out of, my lord.
you can tell me later.
3 out of 9. 3 out of 9.
Oh.
So now these witnesses have not supported the prosecution's case. But assuming that part, if your lordship is also not inclined to examine that part, the prosecution's case as presented in the charge sheet, whether it establishes that the house belongs to me and whether it establishes that there was conscious and exclusive possession on my part, since there was no direct physical possession, my lord. If these 2 things can be established by the prosecution, my lord, then 37 will come in and I'm not entitled to bail. But without these 2 things,
In
my
that
lord,
case, we'll have to direct speeding out of the trial.
my lord,
6 more witnesses. Not many, can be.
But
But anyway. so
whatever evidence they have collected and they have presented before the
For
court,
37, can depositions be looked into? I have to refresh actually. Can it?
Mohit Agarwal says that the court is otherwise not required to, and I'll just give the judgment instead of saying it from my memory. Mohit Agarwal, my lord, it discusses what is, your lordship already knows what is the criteria for determining reasonable grounds. But para 15, my lord, the sum and substance, my lord. May I read para 15, my lord? So we may clarify that at the stage of examining an application for bail in the context of section 37 of the Act, the court is not required to record a finding that the accused is not guilty. The court is also not expected to weigh the evidence for arriving at a finding as to whether the accused has committed the offense under the NDPS Act or not. The entire exercise that the court is expected to undertake at this stage is for the limited purpose of releasing him on bail. Thus, the focus is on the availability of reasonable grounds for believing that the accused is not guilty of the offenses that he has been charged with, and he is unlikely to commit an offense under the Act while on bail. But this judgment is otherwise relied upon ordinarily from the prosecution side to say that the evidence cannot be looked in. So that is not exactly what has been said. But what Mohit Agarwal says is that what the court is required to do, not go into to record a finding.
This judgment, subject to correction, I may be wrong also, but this actually, it can also mean, it could have also meant something like this, that, I cannot appreciate the evidence, the materials. Or does it, you think it means that the depositions cannot be seen? Or it means that whatever materials are there, like at the stage of framing charge also, you cannot do appreciation of evidence.
Right.
So that is meant, that can be one.
That also be understood.
The-
But
I think it is meant that,
Well.
that evidence cannot be weigh the evidence. That means you cannot do appreciation of evidence.
Sure.
But yes, somebody might interpret it like that also, since the language is slightly.
what in my respectful submission, what it means is that the court, though when the court has to come to a finding that there are reasonable grounds for believing that the accused is not guilty, the court is not required to record a finding to that effect that he is not guilty. The court is only required, is also not required to weigh the evidence.
Weigh the
To-
evidence means
To come up with
not
finding that
conduct mini trial.
mini trial. Man. So here, my lord, I am not
That could be the meaning.
Yes. Irrespective of the fact that the three witnesses, prosecution witnesses have not supported the prosecution's case, my lord, I'm also not going on that one. I'm simply submitting on the fact of the materials which the prosecution has collected during investigation and produced before the court. Whether those materials prove these two aspects, my lord, conscious and exclusive possession. Anything from record, if these two aspects are established, my lord, then 37 comes in, my lord, and my case goes, my lord. So, my lord, my friend may address this honorable court on these 2 points, that whether this house, whether the prosecution found out any material to prove that this is my house. Secondly, my lord, whether if the contraband is found in the compound, that shows conscious and exclusive possession. When it is accessible to everybody, including residents of the house and other people in the locality.
Maybe. Yeah, an open question that if something is found in my compound, that then maybe I may have to discharge the burden, that and how that it is not in my concern. Will it be like that? By a standard of preponderance of probability, the burden, because the reverse burden is applicable in any case. So I have to discharge that it is not. I did not know about. It could be that. Could it be that?
My lord, 54, in my humble submission, 54 is the predicated on proof of seizure, my lord. Only when seizure is recovery is proved, my lord, from me. Here, my lord, there is no recovery from me. So unless and until there is any
No, not. I think it would be narrow to say that it is to be recovery from the person per se, for
No.
himself. Suppose there is a recovery from the premises. Okay. And then the reverse burden won't it come?
my lord,
Anyway,
my lord,
this is
my
subject to
respectful
debate.
submission, my lord,
that it may
because
come.
possession is that sine qua non is
It's a
possession.
foundational fact.
Foundational fact. Without possession, because admittedly there is no physical possession on my part. I was not arrested with the contraband. So contraband is found in the yard of the house. And so unless and until the prosecution shows that this is my house, it can name anybody, my lord. At least some foundational facts have to be discharged by them to show that this is my house. Without showing that this is my house and only I had access to the house, that foundational aspect is not discharged. And without discharging this foundational aspect, this reverse burden cannot be put under me. I cannot be saddled with that reverse burden, in my respectful submission. So let them address on these 2 points, my lord, then I will reply. Nani.
Yes.
Here, Lordship, I first want to clarify one thing, Lordship. Here is stating that there is a conscious possession. Conscious possession does not mean I have the possession in my hand. It is also that indirect, Lordship, I have a control over that area. That also means conscious possession. It does not mean it has to be with me, Lordship.
Dominion.
I have a dominant over that area. So it is a compound.
Physical plus mental element.
Mental element is also there. That also looking to be corpus, Lordship. That corpus thing
Suppose
also
a bag is kept here. It is not kept here.
not
Kept here.
It
but
may be kept in that
but it
area
is
also,
my
but
bag.
it is in my control.
Something like that. I
That
know
also
it's
be
my bag.
that also be need into account.
Anyway,
Firstly, that need to be account. Moreover, Lordship, yes.
Next, that is your first submission. that mental element.
Lordship.
Can we see the FIR once?
My lord. The Lordship will find the FIR at page 9, sorry, my lord, page 13.
See how it started.
My lord. May I read the FIR, my lord?
Can read.
With due respect, I would like to submit that as per GDE number so and so, dated so and so, today at around 7 p.m., acting on information received from a confidential source, one Muhammad Abdul Qayyum and Tinku Ali of Nagaon town, involved in the business of NDPS contraband, were arrested and interrogated. Based on their statements, following their direction, they took us to a vehicle, a Tata Indica bearing number so and so, which was kept in the front yard of one of the houses of Pulok Juti of so-and-so place under the jurisdiction of this police station. And inside the vehicle, a total of 11 cartons of so-and-so cough syrup. Then, madam, this part is regarding Pulok Juti. Now, next part comes regarding the petitioner. Madam. At the premises of Lachit Bora, hidden in the front yard, a total of 16 cartons of cough care tea, 100 ml intoxicating cough syrup, 1600 bottles. And on the front yard, on the scooter of Ajoy Bora, this is a different accused, my lord. Bearing registration number so and so, 1 carton of cough care cough syrup was recovered and seized in the presence of witnesses. Sensing the presence of the police, Pulok Juti, Kolita, Lachit Bora, and Ajoy Bora fled the scene. During the interrogation of the accused Abdul Qayyum, Tinku Ali, and other neighbors, it was learned that Pulok Juti, Kolita, Lachit Bora, Ajoy Bora were involved in the business of narcotic substances for a long time. No valid documents were submitted for the aforesaid contraband.
If I look into the Caesar is also, I have flag mark lot.
Caesar, which
I have
page?
flag mark lot.
Where?
The scan copy.
In the sky.
I've written lot of Caesar is.
Yes, I am on the Caesar list.
Lordship.
No.
The series in this house lordship. And moreover, lordship, in regarding to the Caesar witnesses, lordship, there are 5 independent witnesses are there. Only 2 are over.
3.
Or 3 are over, and 2 are there. But I have not access to the third PW lordship because it is not in the record.
I have a copy, my lord. I'm giving us.
You're saying that there are 3 witnesses.
There
There
are,
an example.
as he has given me the third PW lordship, but in the record there are 2. I'm not on that confront that I deny that this is not lordship, but I want to focus on that there are 5 witnesses. 2 are again there. First 2 are not. They have stated that they have just stated to sign the lordship. The signature is signed. They don't know anything. Although in this witness I have not read lordship. Okay. However, 2 witnesses are also there. And moreover, lordship, regarding the pace of the trial, lordship, it is on 34/2024. Its charge sheet has been framed, and it was on charge framed on 31/5/7, lordship. 31/7. Until now, 3 are already over, lordship. Only 6 are there. So it is going on a fair trial, lordship, with a good pace, lordship. Pace is also good. It is not that it is prejudicing. And moreover, lordship, moreover, section 54, the presumption, the burden is on them, lordship. Because we have to first prove prima facie, lordship.
Anyway, let's have a look at the charge sheet.
Lordship.
Charge sheet, my lord, I have annexed. Your lordship will find
Yes, I found 19.
page 19, my lord.
From your litigant, 16 cartons, this is the allegation.
This is the allegation.
1600 bottles in 16 cartons found.
Moreover, another point is also there, Lordship. Section 27 will also come of evidence act, Lordship. Because the accused person has led to that place, Lord.
Co-accused.
Co-accused.
It is much.
My lord, I'll just take 2 minutes to reply to what my learned friend has said, my lord. First of all, my learned friend, I don't like to give physical examples, my lord, but my learned friend has given an example that if contraband is found here, I'm taking on his example, my lord. If a contraband is found in the premises of this building, my lord, so who will my learned friend attribute it to?
No, this is I mean.
Because that is the example which
No, no,
he took, my lord.
Public building is slightly different.
Yes.
But
My-
very different, Lord.
In my case, my lord, the first thing which I raise, my lord, is whether this house belongs to me or not, my lord. So my learned friend has not answered. Has not answered that, my lord. Whether this house belongs to me, any material which they have submitted or they have collected during investigation. That is the primary aspect, my lord. At the end of the day, making an accusation is not enough. Since investigation is over, they have collected materials. So what is that material which shows that house is me? Of course, if my friend says it's a sketch map, my lord, it's a different thing, my lord. But that has to be there.
Sketch map is there?
No, I'm on not that.
No, I want
Oh, yeah, I have
the
not
sketch
seen
map.
that. It may be there, but one
Sketch
thing
map is
is,
there, my lord.
one important thing is there, Lordship. I have seen in the scan copy that CD is not available there. CD is not available. Scan copy of the CD is not available because the IO has submitted it without submitting the CD, Lordship. So I cannot look into the
Nowadays, they
facts,
don't
Lord-
give the CD, they give the statements and all that.
Lordship.
The-
So I cannot look into that the fact, Lordship, whether any ownership
No.
document has been collected or not, Lordship.
That would be
Or
there.
how they have come to the conclusion that this house is his, Lordship.
He should have said this at the start, my lord, just spared this honorable court's time, my lord. But then the materials in the charge sheet would have disclosed. And second,
Do we call for the case diary then, but it will waste time. Plus,
Mm.
it'll-
and second aspect which he has not addressed, my lord, is since it was not found in my house, presumption under 54 will only come when it is found in either my physical possession or conscious possession. Finding it in the yard, which is why have I been implicated in this case and not my family members, since they also reside in the same house? Can the state say that only one particular resident of that house is culpable?
No, they
Other
got
than-
some information probably that he's doing, these people are doing, so they went there. Anyway, so that is a speculation also to some extent.
Yes.
Kindly, let us read the statements of all the Caesar
Lord,
witnesses, all the Caesar witnesses. You have to help me with the handwriting.
Lord.
It's problematic. Yeah, it is there.
Yes, yes, yes. These two aspects only matter, conscious possession and exclusivity of possession. 54 otherwise will not come without these two aspects, my lord.
Because if we go too deep, it will prejudice the trial, right?
But without material keeping me in custody also prejudices me, my
Yeah,
lord.
that's true.
Take it. The CD part is there, my lord.
It's there.
In the first page, it is
For our purpose, it will do.
but in the first page, it is stated that Lordship, CD is not there. That is why, Lord. I apologize for that.
No, no, it's okay, no problem. None of us are perfect.
Okay, after some time, then I will look into it, Lord.
Statements, can you just read it, Lord, or it's problem for you also? Because for me, it's a problem.
Lord.
If you find it legible, then you can read it. Just read it. Then I can be kept.
Okay, my learned friend will read it. Lord.
Yes.
I cannot.
Don't worry. no problem.
The statement of one, my Lord, Debojyoti Bora, my Lord.
Wait,
So,
wait.
Yes.
Caesar list, who are mentioned? Which are the
PW3
names
man.
of the witnesses on the Caesar list first?
Caesar.
3 witnesses.
Debojyoti Bora is PW3, whose evidence I have given, my lord.
Then I have to read.
He has become hostile.
That মোৰ from Debojyoti's statement is my lord like that যে মোৰ নাম আৰু ঠিকনাৰ ওপৰত লিখা মতে সত্য মই আজি ৰাতি প্ৰায় 8মান বজাত দোকানৰ পৰা ঘৰলৈ আহি থকা অৱস্থাত আমাৰ গাঁৱৰ পুলকজ্যোতি কলিতা আৰু লাচিতৰ ঘৰৰ ওচৰৰ গাঁৱতে দেখো তাহাঁত দুইটাকে ঘৰৰ পুলিচৰ CRPF এৰি আছে আৰু ঘৰটো আছে মোক পুলিচে ৰাখিব কয় আৰু লাচিতৰ আৰু পুলকজ্যোতিৰ নেকি পুলকজ্যোতিৰ ঘৰ থানা তালাচী কৰিবৰ সময়ত পুলিচক লগত মোক ৰাখে লাচিতৰ ঘৰ থানাত তালাচী কৰি পুলিচে লাচিতৰ ঘৰৰ পিছফালে মজুত ৰখা মুঠ 16 কাৰ্টুন উদ্ধাৰ কৰে উক্ত কাৰ্টুন বিলাকত RUFCC-RE1 নামৰ নিচাযুক্ত কফ চিৰাপ আছিল আৰু প্ৰতিটো কাৰ্টুনত 100টাকৈ বটল আছিল পুলিচে উক্ত কাৰ্টুনসমূহ বটলবোৰ চাই কৰি জব্দ কৰে মই জব্দনামাত হিচাপে চহী কৰোঁ পুলকজ্যোতি কলিতা আৰু লাচিত বৰা আৰু শ্ৰী অমৰ বৰাই প্ৰায় এনে কাৰ্টুন কিছুমান আনি মজুত কৰা আমি জানো সিহঁতৰ ঔষধ দোকানৰ ডিলাৰলৈ বুলি বুলি পাওঁতে কোনোবাই সুধিলে কয় সেইবাবে আমি ওচৰ চুবুৰীয়াই এই বিষয়ে গুৰুত্ব নিদিওঁ
What is his name?
Debojyoti.
Huh? Dhruva Bora.
Debojyoti.
His name is Debojyoti Bora.
My lord,
Debojyoti Bora.
kindly see his evidence also, my lord, PW3.
Turn hostile.
And my lord, another one is my lord Nayan Jyoti, my lord.
He also become hostile.
Nayan Jyoti Kolita, my lord. May I read my lord?
Yes.
জৱাবন্দীৰ উপৰোক্ত মতে নাম ঠিকনা সত্য আজি নিশা প্ৰায় 7:45 8 বজাত আমাৰ প্ৰতিবেশী পুলকজ্যোতি কলিতা পিতা সোয়েনচো শ্ৰী লাচিত বৰা পিতা সোয়েনচো বৰাৰ ঘৰ পুলিচ আৰু বেটেলিয়ানে ঘেৰাও কৰি ৰাখে আমাক মাতে মই পুলিচৰ লগত আহোঁ মোৰ আৰু অন্য সাক্ষী জনৰ সাক্ষাতত পুলিচে লাচিত বৰা আৰু পুলকজ্যোতি কলিতাৰ ঘৰত তালাচী চলাই উক্ত তালাচীত লাচিত বৰাৰ ঘৰৰ পিছফালত মজুত কৰি ৰখা ফ্ৰেঞ্চো নামৰ কাপ চিৰাপ মুঠ 16 কাৰ্টুন, প্ৰতিটো কাৰ্টুন হিচাপ কৰাত 100টাকৈ বটল 100 ml লৈ পোৱা গৈছে। লাচিতৰ ঘৰৰ পদূলিত আমি খোৱা স্কুটিৰ ফ্ৰেঞ্চো নাম্বাৰৰ চিৰাপৰ এটা কাৰ্টুন পায়। উক্ত স্কুটিখন আমাৰ গাঁৱৰ অজয় বৰা পিতা ইমান বুলি মই জানো। লাচিতৰ ঘৰৰ পিছফালে পোৱা উক্ত কফ চিৰাপ সমূহক জব্দ নামাত আৰু স্কুটিত পোৱা কফ চিৰাপৰ জব্দনামাত চহী কৰোঁ আৰু পাছত পুলকজ্যোতি কলিতাৰ ঘৰত খানা তালাচ কৰাত তেওঁৰ ঘৰৰ চোতালত ৰখা চো নং টাটা ইণ্ডিকা গাড়ীত মুঠ 11 কাৰ্টুন নামৰ কফ চিৰাপ জব্দ কৰিব সক্ষম হয়। ইয়াৰ প্ৰতিটো কাৰ্টুনত 120টা বটলকৈ 100 ml ৰ 4 বটল আছিল। 4 বটল মানে চিৰাপ বটল আছিল। পুলিচে মোৰ উপস্থিত উক্ত ইমান টাটা ইণ্ডিকা খন আৰু তাত পোৱা উক্ত কফ চিৰাপ সমূহ পুলিচে জব্দ কৰে। এই জব্দনামাত চহী কৰোঁ আৰু আমি বহুত দিনৰ পৰা লাচিত, পুলক আৰু অজয় তিনিয়ে কাৰ্টুন অনা দেখো আৰু কিছুমান ল'ৰাই স্কুটি মটৰ চাইকেলেৰে ঘৰৰ পৰা লৈ যায়। সিহঁতে গাঁৱত ঔষধ চাপ্লাই ডিলাৰ লৈছে বুলি মিছায়ে আমাক কৈছিল বুলি এতিয়াহে বুজিব পাৰিছো। পুলিচ অহা উমান পাই তেওঁলোকে ঘৰৰ পৰা পলাই যায়। কিন্তু ঘৰৰ লোকেও উক্ত মজুত ৰখা কফ চিৰাপ সমূহৰ কোনো নথি দেখাব নোৱাৰাত পুলিচে জব্দ কৰে। ইণ্ডিকা গাড়ীখনত লাচিত আৰু পুলক দুয়োৰে ব্যৱহাৰ কৰা দেখা পাইছো। অজিত বৰা. But another one is also there, my lord, one Ajit Bora, my lord.
You can read it and tell me the contents
Yes.
gist. Flip through it and tell me the gist. Meanwhile, I'll just have a look at.
Yeah, for. No, সেইবিলাক কমিব। ভোটাৰ পেজেছ এটা। Question আৰু। Similar, অকমান Ajit Bora's, my lord, that statement is also, my lord, similar 151 statement. My lord, he also stated that, my lord, they are from the car and from the, my lord, that is the residence.
Case map is there.
Case map, okay.
You can have a seat.
Well,
Well. Good night. Please.
Moving below. That's it. I have found it. Sketch map I have found.
Which date?
Sketch map is there. Look.
Charge framing orders there?
I have an next, my lord.
Third frame is there. He has an.
That is at page 38, my lord.
It is in the can copy also. Lord.
You reply and then I'll start.
First, there. Okay. If you did.
Just my lord, one small submission, not take much time. The three witnesses which my learned friend has read out, all three have been examined. None of them has supported the prosecution's case. That is, what was it? What?
Other product, one other given.
So, my lord, three prosecution witnesses have, anyway, three prosecution witnesses have been examined. They have not supported the prosecution case. And this issue, my lord, remains whether, and that is the only prayer, my lord, lordship will examine. Otherwise, your lordship will decide whichever way it goes, my lord, that whether my conscious possession and the exclusivity of possession with me regarding the contraband which was found in the backyard, as they have read out, my lord, that can be attributed to me, my lord, prima facie. And regarding the 27 thing, my lord, your lordship knows 27 thing is regarding those two persons who brought the police to this place of occurrence, to this place which is allegedly being called my home.
That will be at the trial.
That will be the trial, my lord. But then that cannot be taken against me, my lord. Their statement to that effect that this was found in the backyard of the house. Because if they have access and they could bring it to the backyard of my house, then that responsibility may also go to them, my lord. So exclusivity and conscious possession, my lord.
Sit down.
Oh.
Heard. Nawaz. Mr. Das. Mr. Das. And granted additional PP for the state. Invoking section 483 BNSS. The petitioner herein, namely Lasit Bora, is seeking regular bail in connection with special NDPS case number 165 of 2024, which is pending at the stage of trial for the learned additional session judge number 2. Now, the case originally arose out of an FIR dated 26/7/2018, whereupon Nagaon PS case number 2535/25 was registered, which after investigation resulted in a charge sheet against 3 accused persons, including the present petition.
5 accused persons.
5 accused persons.
Five
sorry,
accused.
5 accused persons, including the present under section 21C of the NDPS. Subsequently, by order dated 31/7/2025, the learned additional session judge number 2 was pleased to frame charges against all the 5 accused persons, including the present petitioner under section 21C, 25/29 of the NDPS Act 1985. Full stop. The trial is in progress and it is submitted. It is, and admittedly, out of 9 prosecution witnesses, 3 witnesses have been examined. Mr. Nawaz, learned counsel for the petition, primarily contends that the, oh, sorry, you have to give the allegation. The allegations in the FIR giving rise to the case was that 2 persons co-accused within bracket, two persons, namely Abdul Qayyum and Tinku Ali within bracket, both co-accused, were arrested based on a confidential information about running of drugs business. Semicolon, comma, that based on their statements, the police recovered, allegedly recovered contraband from 3 locations. With regard to the present petitioner, Lasit Bora, it is alleged that based on the statements of these 2 co-accused and upon being led by them from the premises of Lasit Bora and hidden in the front yard, a total of 16 cartons of Cough Care Tea 100 ml intoxicant cough syrup totaling 1600 bottles were seized in the presence of witnesses. Full stop. So we'll go for the contentions. Mr. Nawaz, learned counsel for the petitioner, contends that the petitioner is not involved in the alleged offenses and that there was no recovery from his possession, recovery of any contraband / narcotic drugs from his possession. They submitted that it is not recovered, is neither recovered, full stop. The contraband was also not recovered from inside his house and that it was recovered from his backyard, and that the same place is open to others. It is also contended that the house comprises, the house has other inhabitants as well, and that prosecution has not been able to show conscious possession of the petitioner to attribute liability to him. It is also stated and submitted that the police did not seek him out during the investigation, or that the police showed him as an absconder in the charge sheet, but subsequently he appeared before the learned trial court, and after rejecting his bail at that stage, the learned trial court was pleased to remand him to judicial custody, where he is at present. The learned counsel has also placed before this court a judgment of the Honorable Supreme Court rendered in the case of Narcotics Control Bureau versus Mohit Agarwal, 2022, 18 SSC 374. Full stop. And draws attention to para 15 and contents in this context that there is no bar perhaps to look into the evidence adduced at the trial. Full stop. In this context, placing a copy of deposition of PW3. In this context, it is submitted that other the 3 witnesses examined, 2 have turned hostile. Full stop. The scanned case report was called for and has been received, containing relevant documents So, so thus the learned additional public PP representing the prosecution submits that that the bar of section 37 would be applicable in this case, and that the prosecution opposes the grant of bail. The quantity in question pertains to commercial quantity. It is submitted that there has been due recovery from the premises of the contraband, and that it cannot be said that the petitioner was not aware of the said contraband found buried in his in his compound. Full stop. It is submitted that the contraband was duly seized in the presence of witnesses, and during investigation, in their statements recorded during investigation, the witnesses have supported the seize. The learned additional P submits that the bail may be rejected at this stage in view of the statutory bar. I have perused the relevant materials and considered the rival submissions. Before proceeding for the contents of section 37 of the NDPS Act may be reproduced here in bill. It follows from the statutory provision that wherever the same is applicable, the bail same is applicable. Bail can be granted only if the court arrives at a determination on the basis of relevant materials that there are reasonable grounds for in italics that dash there are reasonable grounds for believing that the petitioner, the accused, is not guilty of such offense, and he is not likely to commit any offense while on bail. The section 37, next paragraph. Section 37 is applicable to offenses of the NDPS Act under section 19, 24, 27, and also for offenses involving commercial quantity. In the instant case, the provisions of section 21C has been given pertaining to commercial quantity. The case, the applicability of section 37 is to be adjudicated. The next paragraph, the statutory provision does not enunciate specifically the materials that have to be seen by the court to make the determination. In this regard, the relevant para 15 of Mohit Agarwal Supra may be reproduced here in bill. Full stop. As the statutory, considering that the statutory principle, statutory provision is silent on the materials to be considered, and upon perusing the aforesaid paragraph of Mohit Agarwal, dash, in my considered opinion, what follows from it is that all the relevant materials have to be considered and the court is only barred from conducting a mini trial by way of appreciation of evidence. Next paragraph. As already stated in the FIR, initially there was a confidential source information. Confidential source getting late. No. So confidential source information. And on the basis of that, premises were raided and the large quantity of the suspected contraband in the form of suspected psychotropic substance was seized. Full stop. I perused the copy of the I perused the copy of the sketch map available in the record, which indicates the place in the premises from where they were seized. The learned prosecution has taken the court through the statements of the three Caesar witnesses who have stated on similar lines. No, similar lines. That dash, small italics. That that the witness that they were asked by the police to be witness for the operation. Semicolon. In their presence, the contraband in the form of this cough syrups in cartons, in multiple cartons, were seized and from the premises of the petitioner, being buried in the ground, being found buried in the ground. Full stop. The semicolon that they had information and were told earlier that the petitioner deals in medicines and supplies them to pharmacy, and that, but in the context of the present developments, they have come to know that they were indulging in this keeping this contraband. One of the Caesar witnesses has also stated that he has seen youths coming in two-wheelers and taking these medicines. Full stop. Next paragraph. No, there is no specific statement of the petitioner that the house premises do not belong to him. Full stop. So it is contended that the other family members also stay. Full stop. While making a determination under section 37, some degree of cautiousness is necessary so as to not cause any prejudice to either the defense or the prosecution. Full stop. After framing of charge in a case where section 37 of the NDPS Act applies, making such a determination and making such a balanced determination becomes even more challenging. Coming back to the instant case, upon perusing all the available relevant materials as referred to and narrated above, and keeping in mind the requirements under section 27 I am unable to hold that there are no reasonable grounds to believe that the accused is not say guilty. Therefore, it has to be said that the test of section 37 NDPS is not passed in favor of the accused. In prima facie, even this court would be statutorily barred from granting bail to the accused at this stage. Further, as he is in under trial detention since 23/5/2025, it cannot be said that the principles of the statutory bar would be subservient to the principles under Article 21 of the Constitution of India. Accordingly, in the given facts and circumstances, and in view of the above discussion, the incident bill petition stands rejected at this stage. Two more lines you kindly write. Yes, it may be mentioned herein that nothing stated in this order shall be constitute to be expressing any opinion on the merits of the matter pending for trial, either to the prejudice of the defense or the prosecution. Further, as the trial is already in progress, the learned trial court is requested to kindly complete the trial expeditious. The
Deeply
incident bill petition stands dismissed and disposed of on the aforesaid grounds.
Much obliged.
Just
Deeply
take a 2-minute break. Huh?
That Your Lordship, FIR, Your Lordship will find, starts from page 11 and relevant portion, Your Lordship will find page 14. Yeah, specifically, they stated that on secret information, they apprehended one vehicle, and from vehicle, they recovered, Lordship, 2,000 numbers of Yaba tablet. And accordingly, Lordship, the driver and handyman were arrested. That Your Lordship will get at page 15 and my role, Lordship. Page 15, third paragraph, it starts with during spot interrogation.
Just a. During,
Lordship, got it?
during spot
Yes,
interrogation.
during
Then-
spot interrogation, the detained driver identified himself as Samimuddin Beg. So I am not that, Lordship. My name is Abu Muhammad Tanjib. Samimuddin Beg, so and so. Moreover, the co-driver of the vehicle identified himself as Tanjil Abedin Talukdar. So and so. Upon questioning, they admitted that they were transporting drugs which was kept concealed within the secret chamber of gearbox of the aforesaid vehicle. They also confessed that as per instruction and investment of the owner of the vehicle, namely Abu Muhammad Tanjir. So now my name come. They often transport such type of narcotic contraband with this vehicle. They agreed to cooperate in facilitating the search of the vehicle. So accordingly, those search procedures were carried out and those were recovered, Lordship. Now, Lordship may kindly say, during investigation, I filed a bail application before this Honorable Court. Your Lordship's order is there, page 22. And relevant paragraph, I am taking Your Lordship to paragraph 12, that is page 25. Needless to say that the said self-incriminating statement of the accused constitutes inadmissible evidence. At the same time, upon perusing the case diary, I did not notice other materials at this stage, apart from the implicating statements of the co-accused about the involvement of the present accused in trafficking of illegal drugs. So that was the only material during that period of time, Lordship. Now, charge sheet is submitted, Lordship. What material they got, Lordship may kindly see at page 41, Lordship. In page 41, top portion, Lordship, phone numbers are given, Lordship, that belongs to other co-accused persons, names are there. Page 41, top portion, Your Lordship. that no phone was seized from his possession. So I'm reading that third paragraph, Lordship. During investigation. May I read?
Yes,
During investigation, the PO was visited and drawn up the sketch map of PO, examined the complainant so and other available witnesses, persons, and recorded their statements under section so. In course of investigation, a huge quantity of narcotic drugs contraband suspected to be Yaba tablets, approximate 80,000 numbers, gross weight 8,576 grams, were recovered and seized from active joint possession of arrested accused persons at the PO. So that at PO, Lordship, the other two accused were arrested. So from them, it was recovered, which was being concealed within the secret chamber of gearbox of the vehicle number so. It came to light that the seized contraband of drugs suspected to be Yaba tablets are being illegally transported from Mizoram, bordering in Indo-Myanmar side of Mizoram state to Sribhumi, Assam, in conspired and associated with the owner of the seized vehicle, namely Abu Muhammad Tanjir, and on whose instruction and investment they have been engaged in often transport such type of narcotic contrabands with this vehicle. So this is the same as reflected in the FIR also. Now, after one paragraph, Lordship will get, it is to be noted that the arrested accused persons, namely Samimuddin Beg and Tanzil Abedin Talukdar, are the veteran kingpin of drugs trafficking and who also has conspired in transporting of drugs from Indo-Myanmar side of Mizoram to Assam Sribhumi district as their usual business for earning illegal money. And whereas the arrested accused person namely Abu Muhammad Tanjir is the owner of the seized vehicle, registration number so and so, who is the main felicitator and financer to the smuggling of drugs from Mizoram to Assam Sribhumi district for illegal business since long days. But just one thing I'm pointing out before Lordship, they says that I am financer, but no 27A is there in the charge sheet, Lordship. Accordingly, on the strength of FIR, the accused, namely Samimuddin Beg, Tanjil Abedin, and Abu Muhammad Tanjir were arrested and forwarded them to judicial custody in connection with the case. In course of investigation, the inventory was prepared. So this is regarding.
now we have to see the materials with regard to this person.
Lordship, my humble submission is that apart from the co-accused statement, there is no material against the present petitioner. And only being he is arrested because Lordship, he is the owner. That in the said paragraph, your Lordship will find that in course of investigation, inventory report of the seized vehicle number so and so is collected from DTO Sribhumi along with the detailed particulars registered ownership of the seized vehicle, and as per the inventory report of the seized vehicle number so and so belongs to the arrested accused Abu Muhammad Tanjir. And in fact, this vehicle was given on lease to other person, Lordship, that your Lordship will get page 45. So probably in my humble submission, Lordship, subject to what my learned friend says, there will be no CDR details with the drivers also in that. I'm not saying about the contents of the CDR, but even CDRs will also probably not be there.
Lordship, as per office note dated 4/12/2025.
Can you increase the microphone slightly? Speak comfortably.
Lordship, am I audible, Lordship?
Yeah, better.
As per office note dated 4/12/2025, complete CD as per requisition has not been received. So we are unable to see the complicity of the present petition.
Probably on
Yes,
last.
Complete CD has not been received as per office note dated 4/12.
Office note is there.
Yes.
Complete CD case diary as requisition has not been received. Scan
Full
copy
CD is not received.
and can you have a look? Also, you have already checked.
Yes.
So in that case, we'll have to call for it then.
Yes.
Around last occasion,
Mohit
probably
Agrawal
case diary was there and they sought time only to see whether there is any other material against me or not, Lordship. As per. Last time is cancelled.
Since the alleged offense involves commercial quantity,
Yes,
Lordship,
it has to be seen, then
it has to
kindly
be
get,
seen his complicity in the alleged crime first of all, and secondly,
you have to keep it part-out then.
yes, if
Part
the,
one.
not part.
Already is rejected by your lordship, it will come to your.
Oh,
And if the other mitigating factors is against a petitioner,
Hmm.
then
no, just, things like that, that is the law of the land. I mean, academically.
So we
can
cannot
discuss, But,
overcome section
yes,
37.
37 is the Tufan Singh says that, only on the statement of co-accused, a person cannot be,
That is at the time of trial,
Right.
at the time of conviction.
yes,
So,
No,
so for
yeah,
it, Lordship,
trial,
during,
right? Will not take this time, but
yes,
37. So, but actually that principle originally comes from, I said it once before. That principle actually comes from the evidence.
yes,
That co-accused accomplice is
that is
is
not
a
admissible.
less reliable witness.
Yes, in it,
So he needs corroboration.
Yeah.
Fine, that's fine.
yes,
Otherwise, it will be risky.
yes,
Co-accused can also implicate someone.
yes.
So that it follows from there. Now, question is that there is no authoritative pronouncement on this point, but there are indicative pronouncements.
Yes,
That
Tufan Singh
if
case.
the only, because at the stage of investigation, it may be premature to say
Yes.
sometimes.
Yes.
But after completion of investigation, then you can say that
Yes.
at that stage, after completion of investigation, the only material against the person
Yes.
is that
Only
is
co-accused
the
statement.
statement of co-accused,
Yeah.
and trial proceeds on that premise.
Yes,
Then this principle will come.
yes, otherwise, but
He will not be,
at the same time,
cannot be held guilty.
yes,
And therefore, there can be one reasoning, one argument that therefore, on these basis of materials, since he cannot be convicted, therefore one can also say that there are reasonable grounds to hold that
yes,
he is not guilty means he is not likely to be held guilty.
yes.
I read it like
That
he is
presence
not
has to
likely
be-
to be held guilty.
The burden on us lies of the
Yes,
court.
but something else may emerge in the process during the evidence, but that we cannot. That is a matter of speculation. Now. We do
Speculation.
not know.
We do not know.
So get that, but we must have the complete materials before us
Yes.
to make that.
Other mitigating factors we have to look at.
37, regarding 37, what my learned friend says that Tufan Singh can be relied on in the during trial. That probably is not the law. Supreme Court has said, lordship, that Tufan Singh can be used in regular bail also.
No, I think
There are judgment I can place.
subject to
That
correction. You can show me because I'm trying to learn that. The point is, the law point is very clear for stage of trial.
Got it.
But it has not been precisely and pinpointly said that if it is at that stage of, if it is, if this is the only material, then bail has to be granted.
Got
It has not been indicative enough. That's why I said.
Nothing,
But
nothing.
you can certainly take into account.
But there are coordinate bench
Please,
judgment of
sure.
our High Court
Yeah,
and
I
which
think-
relies on Supreme Court judgment. also. That-
Because if that is at the after completion of investigation, that is the only material. Then probably, as I said, you can probably say that he is not likely to be held guilty.
Yes,
Therefore, that can satisfy 37.
Lord.
Maybe.
yes.
That
Let
is
us-
what
let
lordship,
the
our
court make
coordinate
the-
bench says.
Well, the lordship may decide after receiving the complete statement. Because materials are not.
Heard Mr. A. Ahmed, an additional PPSH for an earlier bill petition. So I can keep it part heard because it will come before me only.
Lord.
Because it's a
It is earlier rejected by your lordship. Automatically it will come to your lord.
Not, not required to be mentioned as part of lordship.
Sure.
It will automatically. come to
automatically.
your lordship.
So issues that he addresses some arguments on the matter and contents, primarily contents that now investigation trial has not started.
Trial lordship, charge sheet is submitted.
About to start.
Recently charge sheet submitted lordship. So
Recently.
probably.
9 2000.
Charge sheet has been submitted, though trial has not yet commenced. So it is, and that on the basis of the completed investigation materials, the only incriminating materials against the petitioner are the statements of co-accused, and therefore applying the principle laid down in Tufan Singh, with the state of citation to the test of 37, the rigors of 37 would not be applied. That is your contention. Learned additional PP submit that though record has not been, some records, scan records have been received, but complete case diary has not been received, which has also been mentioned in the office note dated 4/12/2020. The issue requisition for the remaining part of the case diary in other words, the complete set of the case diary in a scan form. List the matter on. That did you tell?
Immediately after vacation.
After vacation.
6-1.
Lords.
Because
All right.
Otherwise, these are very serious offenses. They have to-
Lordship.
The police
because-
has to do, police investigation in NDPS cases has increased. Of course, we are doing a professional duty. We are doing a, it's not,
During the,
their investigation is improved, but they have to do solid homework. That's all these things, everything they have to do. CDR, everything.
co-accused statement is the sole basis of investigation, Lordship.
No,
Only on
that
the
they-
basis of that
True.
investigation.
But that's the law.
Yes.
He cannot be, he may be the main person. But he cannot be convicted on the, he'll, suppose, it's there, they have to do thorough investigation, and my experience is that many Caesar witnesses turn hostile. Therefore, the prosecutor should never start with the informant. The informant is a police officer.
Lordship.
He'll not turn hostile. You should start the trial at the earliest with the Caesar
Caesar
witnesses.
witness.
Many
Yes.
of them turn hostile, Caesar witnesses. Many things out of sympathy also sometimes. Co-villager,
Yes.
sympathy also.
And even our lordship,
This is-
coordinate bench
Done.
says lordship that in
Official statements of the co-accused, that cannot be the basis of conviction. But in case of deciding a bail application, Lordship, while the contraband is commercial quantity, then section 37 will come into.
no,
if the other
section
mitigating-
37
other
is not a
mitigating
complete
factors-
bar. That is what
If there are
I'm
other
saying.
factors, then certainly.
Certainly.
But as I said, no, we are still awaiting an authoritative pronouncement as to what will be the outcome of such a thing at the stage of bail.
Yes.
Even with regard to section 50.
Yes.
Suppose 50 is not
Yes.
complied. No substantial compliance in 50.
Yes.
Acquittal at 50, wherever 50 is applicable.
Yes.
But suppose you find prima facie material that 50 is not compliant. Will he be entitled to bail as a matter of right? That is
Only
also,
because of
that is
procedural
also
factors.
awaiting an authoritative pronouncement.
Yes.
If I miss something, I don't know. I mean, law is so vast.
That's
There is one judgment lordship where lordship
Yes, sir.
section 42 was not followed, so bail was granted by the honorable
So it
apex
can
court.
always be taken into account, but automatic,
Yes.
right? So
That
that's
is a
the
mandatory.
law is so vast. We can always miss. But nowadays you can use technology
Okay.
to search.
22.
Obliged.
This.
Fair please, Your Lordship. Lordship,
22.
Lordship, the petitioner is behind the bar since 15/10/2025, Lordship.
Let's go a bit faster.
Lordship, the
Not
allegation
fair to
is
say.
60 days offense, Lordship, and including today, he is 58 days behind the bar. Lordship.
Nice. What is the allegation?
Allegation is under section 76 and 77, Lordship. Lordship, deserve and voyeurism. First one, deserve is not applicable in this case, Lordship. On the basis of the FIR. And voyeurism, he has captured some videos of girls, Lordship. That is the allegation, Lordship.
Oh, totally.
Taking photograph
Punishment up to 3 years, Lordship.
secretly without the knowledge of the victim.
Punishment up to 3 years, and first, section 76, punishment up to 7 years, but it is not a.
I would humbly, suggest to you, don't just look at the sentence, as I said, sentencing is, it
That's-
can, within sentence, sometimes it is simplistic to look at offenses only by sentencing.
Otherwise, Lordship, the
Because
video.
many things heinous can be hidden into it.
Yes, Lordship.
Right.
Otherwise, Lordship, 58 days behind the bar,
Mobile
Lordship.
handset has been recovered.
CD has
Lordship.
been,
CD has been received and mobile handset seized. 14 numbers of some objectionable photos has been recovered. from his
have
mobile.
they been taken down? They were uploaded also.
Yes, Lordship, that is
Because
uploaded
that's
as
the
per the
most
office.
biggest concern.
Yes, and he has also admitted that
Otherwise it can
he
lead
has
to other
secretly
tragedies.
taken up the photographs. He himself admitted, Lordship. Otherwise, sufficient materials are against the
If he
petitioner.
does not harm the girl, then we can allow him.
Yes,
Can allow-
mobile phone has been seized, Lordship, already.
He should not harm the girl.
Length of detention, Lordship.
Foxo is not there.
No, Lordship. 58 days behind the bar, Lordship.
Charge sheet not submitted.
Not submitted.
Police, what is meant by habitual extractor in profession? I don't know. What is his meaning?
Lordship, he usually,
Kind, huh?
maybe he is used to it, this Lordship.
These kind of things. Then it's a serious matter.
Dangerous. Contact with someone.
he may harm the victim. 58 days. Now, what is it about to be completed?
Yes.
Lordship.
Huh? Investigation.
About to become 60 days.
These are very serious matters. Otherwise, look at it from the point of view of the guard.
Yes. Can we take instruction or for this?
Mhm. Hmm?
If any condition may be given, Lordship, 58 days, only 2 days left, Lord. Since mobile phone has also been seized, Lord.
And he himself admitted that he has taken up the photographs secretly without the knowledge of the victim. This kind of conduct should not be encouraged.
Yes. If this is true, he is also presumed to be innocent. If this is true that he suffers from perversion, he also needs treatment. As I said, psychosexual disorder.
Not.
Really on length of detention, Lordship.
Third, so additional PPSH for this. Invoking 483, the petitioner who is stated to be in custody since 15/10/2025 is seeking bail in connection with Dispur PS case number 838 of 25 under section 76/77 BNS. Full stop. FIR was lodged on 13/10/2025. That he was found that the accused who resides near the rented house of the informant was found involved in making videos of making their videos. So the case there, the investigation has been received. The IO supported a bail objection contending that the accused is habitually involved in the offense of in the illegal activities of making videos of girls in their private moments and keeping them storing them electronically. The IOS expressed apprehension in the objection that accused may harm the victim by himself or some other way, and may also threaten with death. The learned additional PP for admits that the allegations are serious, and though investigation has progressed, but same is not yet complete. I've also perused the grounds of arrest available in the case diary. During investigation, it was found that his mobile phone, it is stated in the case diary that the investigation found about 40 videos in the mobile phone of the petitioner having such having such objectionable videos of not only the informant, but of other girls as well. This, considering all the serious materials which have been revealed against the petitioner, despite the length of detention, the bail petition stands rejected at this stage. Day after tomorrow, he can get statutory bail if it's not
Lordship,
Yeah, ready to comply to.
really applied.
disposed of. In the context of the, emerging whatever crimes are happening in society,
Yes.
for every penal provision, my personal opinion, every penal provision, there is need for this provision that in every case, the IO can seek extension of the statutory,
Yes, yes,
then upper limit can be fixed.
Lord,
Extensions become necessary, especially in NDPS intermediate context, become very necessary.
yes,
Because it's a one size fits all type model, 60 days for everything,
yes,
even PC Act cases, even other serious cases. So sometimes it may be necessary.
Lordship, obliged.
It will reject it and dispose of. Return back the case directly.
73.
May it please your lordship. Lordship, this is a regular bail application. Lordship, the FIR starts at page number 10. Lordship will find the vernacular at page number 14. Lordship, the allegation against me, the basic allegation against me is this, that taking advantage of the absence of the family members of the informant, Lordship, I have entered into her house at night time and tried to molest her. And when she raised hue and cry, I fled the place. So, Lordship, the incident that has been alleged in the FIR is of 16/7/2025, and the FIR was lodged on 23/7/2025. On that same day, Lordship, I was arrested, and since then, Lordship, I am behind the bars. Lordship, till today, I am behind the bars for 141 days, that is 4 months, 19 days. Lordship, otherwise, Lordship, this is a charge sheeted matter.
Trial has progressed.
Charges have been framed, Lordship. There are 7 listed witness, Lordship, and Lordship, the examination of witness is yet to commence. Lordship, my humble submission is this, Lordship. The allegation that has been alleged in the FIR is not correct, Lordship. Lordship, the actual fact of the case is this, Lordship, that the informant and the accused person, they were having an illicit love affair. And when the husband of the informant came to know about this, Lordship, he forced the informant to file this FIR. Lordship may kindly note the date of incident is
She's a
16
major.
She's a major, Lordship. My only offense is this, Lordship, that I got engaged with a married lady, which I was not supposed to do. Lordship, I have suffered a lot, Lordship. My family members are totally dependent upon me. I'm a daily wage laborer. Lordship, I humbly pray that without going further into the merits of this case, Lordship, I humbly pray I may be allowed to go on bail. I will try to prove my innocence.
Fine, fair. So,
In this case,
can you see if there are any materials regarding its contention?
yes, the victim is implicated, my lord, in her one is.
That is his instruction.
Victim is implicated, my lord. This is not a hard instance, my lord. Earlier also, he tried to entered in her house, my lord, in exchange for a husband. That is reflected from the, my lord, affair itself.
Lordship, the ball of contention here is the husband of the informant.
Earlier also means, yes. So that's why, that assumes even more significant. Earlier also means that aspect kindly.
No,
see.
Lord,
If there is
like
nothing.
There
that
was
we
no
can
FIR,
accept,
Lordship.
then we cannot assume. If there is no material regarding the illicit
regarding, my
relationship,
lord,
then we cannot assume it.
regarding 161 statement, my lord, she is implicated. my lord.
Implicate.
Once, my lord, he tried to enter, my lord, then, my lord, Lord, may kindly see the 161 statement.
to do?
My lord, I humbly pray, lordship, I have already suffered a lot, lordship. And the entire village knows about this illicit love affair, lordship, and
Any villager statement?
No, that it is not specific.
otherwise, lordship, the entire village knows about it. I admit, lordship, I should not have
That
been
is a
engaged.
morally, that's. an
My moral
Uh,
offense is there. I admit that, lordship.
Now,
The
it's
next
all
date
of
is-
But I'm
next date
suffering
fixed is-
only because of
Next date is fixed on my lord 22/1/2026 for evidence, my lord. Let the victim examine, my lord.
He has not, in his statement, he has not stated about his affair.
It is not mentioned.
He has mentioned-
Regarding the affair, my lord, it is not mentioned.
Your instruction may not be correct also, I don't know. Because he said that he was too drunk, so he went searching for his wife on two occasions. Yeah, he admitted that he took drinks, too much drinks, and then he. But
lordship. Otherwise, I have no issue regarding this till 20. I'm waiting for the 21st of January. But lordship, my family is suffering, lordship. I am a daily wage laborer, lordship, and my family totally depends upon me. I earn on a daily wage and I support my family. And since last 4 months, lordship, I am behind the bars. It has been very difficult to sustain my family, lordship. Otherwise, there was no issue waiting till.
heard so and so is positive. Heard so and so. RJ Borwa, 483 bail application, seeking bail in connection with Nalbari PS case number 243 of 25. Under so and so section. Full stop. The case arose out of FIR dated 23/7/2025, lodged by the alleged victim woman with the allegation that on the day of the incident, that is 16/7/2025, between 1 a.m. and 2 a.m., in the absence of her husband, the petitioner entered her house and tried to outrage her modesty. And he had done similar act earlier also. And there was a meeting in the villagers, meeting convened by the villagers, where the accused promised not to repeat such behavior. Also. He has given an explanation in the FIR for few days delay in lodging the same. The investigation is completed and case is stated to be pending for the appearance of the trial. Trial is not started. It is contended that the petitioner is a daily laborer. His family is dependent on him. The learned additional, the scan record has been available, and I perused the statement of the alleged victim woman before magistrate. She has implicated the petitioner. Charge has also been framed under section 331(4) DNS. I've given my consideration to the facts and circumstances in the matrix. Though trial is not, though evidence is not started, nevertheless, considering the projected economic situation of the accused and his family and the length of detention, as also the stage of the case, and also the completion of investigation, dash. The accused is allowed to go on bail of rupees 25,000, 25,000.
Lordship.
One surety of the like mark, satisfaction of the concerned learned court, subject to the following conditions. Number one, He shall not abscond, he shall not hamper or temper dividend, he shall not in any manner, he shall not in any manner intimidate or harass or harm the informant and our family members. Violation of the bail conditions will entail cancellation of the bail. Bail petition stands spoke. I'm deeply obliged, Lordship.
May please. Not approximate, my lord. On last occasion, my lord,
My lord, we have inquired, my lord, from the police station, my lord, service is yet to complete, my lord. Let it come in the next week, my lord.
Service is not yet complete. Otherwise, we would have appointed an MX. Sri Bhumi. Good heart. When do you propose? Which date? Learned additional PP submit that service upon the informant not yet completed.
Or 18, my lord, or 17.
The OC can take steps.
Yes, my lord, that is the 17 or 18, my lord.
The concerned police station shall endeavor to effectuate the the service of notice upon the informant so that the bail matter can be disposed of. List on
17, my lord.
lot of minutes. 17 fine. 7. What is it? Okay, 7. 17.
My lord.
That legal lordship. This is regular bail application lordship. In this case, lordship, the petitioner is in custody since 7/9/2025 lordship. As on today, lordship 115 days. And lordship, the FIR will find the FIR lordship
What is the
and
allegation?
page number lordship only on the basis of the CDR lordship, and they are in custody lordship since 7/9/2025 lordship as on 115 days. FIR will find page number 17 lordship. Type copy lordship.
Is that not received to them, my lord?
And lordship, the petitioner number 1 is the lordship and the law student lordship, and it will find page number 22. And I have annexed the lordship.
The search that case, my lord, scan copy was called for.
And I have annexed the charge sheet lordship and the PM report also.
Not received.
Not received, my lord.
But lordship, charge sheet I have annexed lordship, and PM report also lordship annexed lordship. There is nothing lordship, and the cause of death lordship will find page number lordship. Page number 37 lordship,
Let me just read this.
cause of death. But there is nothing in the
What is
external
this
inferior-
name? There are two people here,
2%.
2 persons.
Lordship.
Name? Yeah.
One Jinnat Ali and another Ismail
Jinnat
Ali.
Jinnat Ali is studying law.
Lordship. And he is a law student lordship. 3rd semester. Only lordship, CDR lordship. There is nothing else lordship.
The CDR indicated that both of them went to the place of occurrence and came back. And the CDR of the deceased showed him at the place of occurrence. Showed him at Alice place.
So the scan copy has already been called for, my lord. The scan copy.
I should better to see it.
Copies
Cannot
lordship.
really say that there is no material. Anyway, but
They are very lordship, young boy
investigation is
lordship, and
complete, but
same locality lordship, and the length of detention maybe, and they will.
they're in custody since.
7/9 lordship. And as on to the
Let us take
115.
one more chance before the petition. The Mr. Houck Learned Counsel for the petitioners fairly summarizes that except for the CDR, there are no other materials, and and submits that as the charge sheet has been annexed, charge sheet copies have been annexed. The bail matter can be disposed. The learned additional 50, Mr. Borwa submits that scan record as
Now,
call for has not been received. Issue reminder for the scan this year comprising case diary and charge sheet and other relevant documents from the concerned learned court.
and Lordship, and now this case has already been committed to the session judge,
Sessions
Lordship.
court.
Session from
Sessions-
Amingaon,
Amingaon.
Lordship. And
Please
the
call.
next date is fixed on 20.
7-1, my lord. 7-1.
I think he wants it before vacation.
Can it,
Yeah, is it okay? 7-1?
but the student at the upcoming exam schedule is here, Lordship, and that one attempt may be
Before
Lordship.
vacation, my lord, only, my lord.
Possible, Lordship. Challenging. Anyway, 18.
Lordship. Published, Lordship, published.
Lordship, in this case, my lord, petitioner is behind the bar for 76 days, my lord.
Charges submitted, my lord.
Her husband is also implicated.
Yes, my lord, all allegation is against husband, my lord. And in her account, 1,50,000 were deposited. That was the instance of her husband, my lord.
Let us approach trial court, my lord.
And he is absconding, my lord. Husband is absconding. Actually, kindly have a look at the FIR.
Any serious receipt? No.
No, okay, charges
Only
charges
charge-
submitted.
And apart from this, my lord, the notice under 47, my lord, was, my lord, was communicated in English, my lord, and she put her signature in SMS, my lord. Page 17, my lord. Which is the recent judgment, my lord.
Yes. Heard. 483 bail application. Long case number 61. Petitioner was arrested on 26/9/2020. He submitted that the main allegations are against the husband of the petitioner. And as per the law enforcing authorities, he's responding. As per it is submitted that as per the allegations, there was 1,50,000 amount of rupees 1,57,000 came into the account of the petitioner. Register of the allegations in the FIR on dated 4/9/25 is that the husband of the accused petitioner in connection with installation of mobile towers took money from the informant on different occasions and amounting to rupees 40 lakhs and 12 lakhs. And that the money was also taken to the account of the present petitioner, the wife of the main accused. They have cheated many people. Huh? The allegation is that cheated many people. She has a child or something at home?
No.
She has not. In every way, you're right actually, that merit should be, it's better if merit is seen. Anyway, in view of completion of investigation, the accused petitioner, herein a woman, is hereby allowed to go on bail of rupees 50,000 with one security of the like amount to the satisfaction of the concerned learned court, which is
The
and
CJM
subject to the
demand-
conditions that number one, she shall be available for the trial if one commences. He shall not hamper or tamper with evidence. He shall not commit an illegal activities. Bail petition stands disposed of. Sorry.
Lordship may mention his search sheet number.
Yes, yes. It is submitted by the prosecution that upon completion of investigation, charge sheet has been submitted by its CS number. So
CS number 62/2025, 62, dated 30/11/2025. And also
Allowed
my
in this post.
objection may be recorded.
Obliged.
Also my objection may be recorded.
Learned additional PP submits that the bail may not be granted at this stage and trial should be allowed to proceed
My lord.
for the moment.
Supplementary 52.
So in this case, LCR was called for, my lord. LCR. My lord, then I may be allowed some time to go to the LCR, my lord, at 2 p.m., my lord, or after.
After two. Obliged.
Lordship, on behalf of Mr. S. Vicious, I'm praying for the timing, Lordship.
In the search sheet submitted, my lord.
Lordship, he is moving before court number 13. I'm praying for timing.
After two. After two.
Grateful.
May I appeal, Your Lordship? Lordship, the FIR, Lordship will find at page 12. The effective portion is at page 16. Lordship, the allegation is that a thief was caught by some local people and he was traced and subsequently he has expired. Lordship, may I read the FIR, Lordship? On 11/11/2025, while I was on duty with ERSS 112 vehicle of Gorsuk Police Station along with AB so-and-so and HG so-and-so at about 3:43 a.m., telephonic information was received from the police control room that one person suspected to be a thief has been detained by some local persons near the Havel showroom near CPWD office, Gorsuk. Accordingly, we immediately proceeded to the spot and found one male person in a weak condition being held by the local public. The said person was brought to Gorsuk PS for necessary action. On being asked, he disclosed his name was so-and-so, and considering his physical condition, he was taken to so-and-so hospital, Pamohi, for medical examination and treatment. At about 9 a.m., his health condition deteriorated again, which he was again taken back to the hospital and subsequently referred to GMCH for further treatment. Later, at about 7:30 p.m., information was received from GMCH that the said person has expired while undergoing treatment. Later, so-and-so of Gorsuk PS examined the CCTV visuals of the Havel showroom, which revealed that a group of local persons were seen assaulting the said person with sticks while detaining him, which indicates that the injuries sustained by the deceased were caused prior to him being brought to the police station. Later on, some of them were identified as, there are 5 names, Lordship, I am at 3. They were all forwarded to judicial custody, Lordship, and in fact, the accused, 3 of the accused has already been granted bail by this honorable court after considering the case diary and the postmortem report. Lordship will find that order at page 21. If I may read from para 3, Lordship. Para 3 of the order, at page 21, Lordship. CD has been called for and received. It is reflected in the FIR that a person suspected to be a thief was detained by some local persons near Havel showroom near CPWD office at Gorsuk. And upon being telephonically informed, police went to the place and the said person who disclosed his name as so-and-so was handed over to the police. Thereafter, the police took him to the hospital for medical examination. However, the health condition of the said person deteriorated and was subsequently referred to GMCH, and subsequently therein that day he expired. It further appears on the CCTV footage that it was revealed that a group of local persons were seen assaulting the said person with sticks while detaining him. The present petitioners were identified as some of the assailants. It is submitted on behalf of so-and-so and para 5, Lordship. Perusal of the postmortem report does not indicate any external injury. And they were released on bail by this honorable court considering the fact that there was no external injury at all. And they were released after a detention of 21 days. The petitioner hearing has completed 29 days as on date.
Diaries come.
Yes, yes, that is received, my lord. The allegation is that, my lord, he tried to commit an offense, my lord, by cutting the pin, my lord. Then, my lord, when my lord, the security person, they saw him, my lord, he tried to climb a tree, my lord, and he fell down, my lord. Then, my lord, police were informed, my lord, that police came and took him to the police station. Now, in the police station, my lord, he was so, he was, my lord, a little bit of weak, my
Yes.
lord, but he was referred to to GMCS, my lord, and GMCS during treatment he died. Now only from the CCTV footage, my lord, witnesses are not directly implicated. Only CCTV footage, my lord, it says that, my lord,
They were beating with sticks.
my lord, after,
It-
my lord, he
Sticks will lead to external injuries.
fell down from the tree, my lord.
He fell down from the tree. As
My
per,
lord.
as per CCTV.
As per CCTV, my lord, they, my lord, while the, my lord, he came down, my lord. So he fell down, my lord, there, so he was assaulted with a bamboo stick. So,
But assault should lead to external injury, definitely,
external.
definitely.
And postmortem report, my lord, the final cause of death has not been nothing.
Have a look.
Yes. It is.
But for the it's, the 483 bail application for case number 304 of the petitioner hearing was not clear. Arrested on 12/11/2020. The case arose out of fire dated 12/11. 12/11/2025 caused by a conflict. The gist of the allegations is that telephonic information was received about thief being detained by some local persons at the stated area. And upon going there, one male person was found to be in weak condition, found weak condition being held by local public. And upon being brought to the police station, his name was disclosed as Prahlad Kolita. And seeing his weak physical condition, he was taken to hospital. Full stop. However, his condition deteriorated and he expired at GMCH. Stop. Later, it is alleged that later the CCTV visuals of the area was examined, which revealed that a group of persons had assaulted the same person with sticks while detained. The 5 persons were named in a FIR as the identified assailants, and the petitioner is one of them. The case diary is called for, has been received. The learned additional PP submits that investigation has progressed but not yet completed. He has he submitted that the witnesses have not implicated directly. Postmortem report stated
In
to
the,
be
it is
not
the second statement. beginning.
stated to be not fully complete with regard to opinion regarding death, but it does not indicate external injuries. So that's very surprising. Anyway, suffered internal injury. The learned petitioner council drawing my attention to draws my attention to an order dated
3/12/2025.
3/12/25 passed by coordinate bench of this court, whereby three of the co-accused who are the co-accused here?
Lordship Azahar Zaman,
Who are
Raju
also-
Burman,
who are also
Kundu.
named in a FIR.
Yes, Lordship. In fact, their charge sheet, they were
granted
forwarded also. by the
regular
court.
bail. We grant regular bail. I have given my consideration to the matter. Seeing in the emerged circumstances, seeing the progress of investigation, the length of detention, the aspect of parity, progress of investigation, the considered view that this accused can also be granted bail at this stage, subject however to suitable conditions. Accordingly, petitioner is allowed to go on bail of rupees 30,000,
Lordship is a security man.
25,000.
Lordship.
One severity of the like and one to the satisfaction of concerned learned court. It is here. It is here only.
I'm sorry, Lordship.
Metro only. CJM Metro.
No, Lordship. Gorsu case, Lord. Yes, sir.
See the method.
CJ Metro.
Subject to the following conditions. Number 1, cooperate with remaining investigation, not empower or temporary, not intimidate or harm the informant, the family members of the victim. Number 3, shall not try, intimidate or try to influence witness.
They will compare to the remaining part of the
Yes,
entity.
I have written. Violation
My lord.
might entail cancellation of the bail. Allow return.
Deeply obliged, Lordship.
This matter is also there. Timing, ma'am.
My lord, that morning matter, my lord, anticipated bail matter.
Item
Item 8,
8.
wherein, my lord, on 8th, the bail matter was considered and also as allowed on the ground that, my lord, the injuries turned up to be simple.
Oh, what was it kept for? For perusing the CD?
Yes, Lordship.
Yes. Nasiruddin Nazmul Rashidul Khairul.
Investigation is not complete, right?
Not completed, my lord. Basically, it was a case of, my lord, altercation between two factions, my lord, two rival factions, my lord, over cultivation over a plot of land, which we were saying that it was ours.
Land dispute.
And, my lord, cross FIRs also have been filed.
Heard, sort of it, stage part. Just a minute, I'm not in public. He ordered. Two. 4. It's 812. BA 3719 of them. 2 and 4. Allegation for anticipatory bail. Anyway. Yeah. This was a submission by your colleague on that day. That medical report on case, previous injury with
Lordship.
laceration.
Others,
One
3
simple injury.
persons, simply. There are 4 persons, I think.
4%.
812. The diary went back or it was here only?
Lordship,
Probably.
we have received it on 4 December.
What is it? It was here only. So investigation.
No,
is-
received on 4th, Lordship.
No, this, yeah. This order is of 8.
8.
So this was the same diary.
Lordship.
So make your submission.
Otherwise, there is a application between 2
Yes,
persons. And
But this was a regular bill.
yes,
This is AB.
person sustained injury, Lordship.
Directly. Good stuff. The Learned Council drawing my attention to order dated 8/12/2025 passed by this court in BA 3719 of 25. Submits that this court was pleased to grant regular bail to one co-accused under similar circumstances, and also draws attention to para 5 of the said order. Heard, the learned prosecution submits that investigation is not yet complete. It was observed in the said order, aforesaid order, on the basis of the case diary and submission of prosecution, that while eyewitness have published. The Learned Council makes a similar submission that the context of these circumstances, the facts would perhaps make out a bailable offense. There is reasonable progress in the investigation, considering that aspect, and next aforesaid aspect regarding regarding the medical report and also the bail within bracket though regularly granted to the co-accused dash. I deem it fit to allow this bail petition accordingly. It is directed that in the event of arrest, 30,000 with 108. Operate with remaining investigation. All other conditions are set. Operate with remaining investigation. Our ABCR. Bail petition stands allowed and disposed of. Return back the case.
My lord.
This time the case diary can go back
Yes.
because they will be needing.
All right.
Highly obliged, my lord.
Fifty-two. 53.
My lord, it is 306. I have given you two judgments. Kindly peruse this judgment and the apex court hold. Even the charge sheet case was quashed by the apex court, my lord. Because there must be an instigation for committing suicide. Otherwise, my lord, it is a futile exercise on the grassroots level. It has been held by the apex court, my lord. So, my lord, I have come to know that my friend, as I came to know, I heard that today I have completed 61 days and charge sheet has been filed. So, in that event, your lordship can grant me bail, my lord. I will face the trial, my lord.
Sir, Lordship may kindly come to page number 16, my lord. Annex are 2, my lord. So since it is a search that case, my lord, the second copy of the record is not available before us, my lord.
Where?
So I'm relying here, my lord. No, page number 16, my lord.
16 of the
So
bail petition.
Bail petition, my lord. So I'm relying the forwarding report, my lord.
Yes.
My lord, Lordship may kindly peruse the ground of arrest, my lord. During investigation, several incriminate evidence, WhatsApp chats have been found against the below mentioned arrested accused person. During investigation, it is found that the arrested accused person has abetted the victim to commit suicide, which is heinous in nature.
We have to see.
If the arrest is not made, then there is every possibility in committing such crime again in future. If his arrest is not made, my lord, these are I'm not relying, my lord, because there is, my lord, in the allegation is that, my lord, he promised to marry her, my lord. That time, my lord, he fixed some other girl, my lord, to marry him.
Whether is it amount instigation, my lord?
So that, my lord,
That's
case
the
that-
dictionary. What is the
that
meaning?
my lord.
Dictionary meaning of instigation.
Since it is a, my lord, search that case, my lord.
Yes, Judge, that's why I'm praying before the Honorable Court.
No, Lordship,
That
we
is,
will have to consider his
court
bail
may bail,
application on merit,
consider
my
the
lord.
bail. 61 days I'm behind the bar. What is the material to convict me? Nothing.
Search that case, my lord, there are material that is.
There is no bar. The charge sheeted case, even a heinous crime also court cannot grant the bail.
Lordship may consider his bail application on merit, my lord.
Yes.
No, if I have to consider, no, bail has to be granted now on the basis of the available materials, if given.
If, my
And
lord, but
the
there
fact
is
of
no,
completion
there
of
is no
investigation.
materials, my lord, because that for that, my lord, Lordship will have to call for the second copy.
On
of the
merit,
report,
that
my
will be necessary, but let me see. It's-
My Ayub versus state of Uttar Pradesh and the Mahendra Wise versus state of Madhya Pradesh, both the judgment of apex court I have placed before a lordship. A lordship will find that alleged harassment or meted out to have left the victim who no other alternative but to put an end to her life. That case of abatement suicide, there must be proof of direct or indirect act of incitement to commit suicide. That is very essential, incitement to commit suicide. In this case, that is no such. FIR is blunt FIR. There is no mention that they are in love, and it is suspected that out of not marrying, that's why she has committed. And there was regular, she used to help the boy with the financial help.
So, Lordship, my lord, for a moment, my lordship, may I take your lordship to page number 22, my lord, of the bail application, my lord.
That is that's why we have challenged.
Page number 22, my lord, third paragraph, my lord. I have carefully perused the bail objection submitted by the IO, the case diary and the case record. It appears from the case diary that during investigation, police seized mobile phone of the deceased as well as the accused. It appears that the police has seized 12 numbers of sheets of WhatsApp chat between the accused and the deceased. In this case, it is alleged that the accused was in relationship with the deceased and he also assured to marry her, but subsequently arranged his marriage with another one of One, and out of frustration, the deceased committed.
So how it can be a 306,
So,
my lord?
there in my lord, the abatement part, my lord, what is the, my lord?
Is it
proximity of the
abatement?
Crime, my lord.
The prima facie, only this much would not be abatement, in my humble opinion. Only this much will not be the breakdown of relationship. It may be even cheating, suppose.
Cheating, my lord.
If
That
he,
is why, my lord,
the
out of
promise was
emotion,
Yes,
he
yes.
committed
from the
suicide.
beginning, but abatement of.
She could go for 417 or
Somebody,
420.
my lord, they were in relationship, my lord. The
Yeah,
first
relationship,
type of
admit.
relationship, my lord.
Girl admit.
No, lordship
She is
will
to help
consider
me
it
with the
as
money.
on
That is the soft
after
soul.
after provision of the scan copy of the record, my lord.
No issue. Let me see this principle. No issue. Don't get agitated. If you have to, both of you have a right to make your submission. Then I will try my best to give a fair decision.
Lordship may peruse this, my lord, materials, and after that, my lord, lordship may allow or reject his application, my lord. That is your up to this honorable court, my lord. My humble submission, my lord, since the charge sheet has been submitted, my lord. So what are the materials collected by the IO, my lord, that has to be looked into, my lord.
Sit down. Yeah, have a seat. It'll take some time. Heard SC Biswas Learned Counsel. RJ Bora Learned Additional PP first. Invoking 483 BNSS, the petitioner seeking bail in connection with Badarpur PS case number 186 of 2025. The case arose out of an FIR lodged by the brother of the deceased on 12/10/2025. It is alleged that on 11/10/2025, his sister committed suicide by hanging. And later, from local people, he came to know that his sister had a love relationship with the accused. And upon verifying her mobile number, regular chats were found. This further alleged that thereafter his sister was cheated, as the accused did not marry her and arranged his marriage at another place. It is alleged that his sister was mentally broken down, and thereafter she committed suicide, which has pained the entire family. Small front legislative. The accused was arrested on 13/10/2025. It appears that in the meantime, investigation has been completed, and it resulted in a charge sheet against the petitioner.
My lord, being charge sheet number 169,
Just a minute. That will leak it. Charge sheet number.
169/2025, dated 10/11/2020.
It is submitted by learned prosecution. The learned Mr. Biswas, learned counsel submits that the petitioner is willing to face the trial and prays for being granted bail. On the other hand, the learned additional people opposing the bail submits that a charge sheet has been submitted. The entire materials may be perused and the bail considered only on merits. The learned counsel for the petitioner has placed on record, placed before the court, two judgments of the two recent judgments of the Honorable Supreme Court.
Both are
on-
25 minutes.
on the, with regard to the law pertaining to the offense of abatement of suicide. Namely, Ayub and others versus State of Uttar Pradesh and another, 2025 in SCC. And Mahendra Awase. Yes. I have perused the relevant materials and considered the rival submissions. From the FIR prima facie, it appears to be uh, uh, a sad story of breakdown of relationship and betrayal in love, leading to the suicide of the girl, causing great pain to the family. Stop. The law pertaining to abatement of suicide, section 306 IPC, and now section, what is the new section now? 108 of the BNS has been a subject of exposition of laws in recent times by the Honorable Supreme Court as well as by the various high courts, including this court. In this context, para 20 of Rajendra Awase, Mahendra Awase may be reproduced here in below. My attention has also been drawn by the prosecution to the order of the learned court below. Learned additional session judge Karimganj, no?
Yes, madam.
Additional session judge Tribhumi, Karimganj, by the order dated 2025. The relevant portions may be reproduced here in below. It is at page 22. Okay, you reproduce this much. Upon considering the entire circumstances, I come to the considered opinion that as the investigation has been completed and keeping in mind the length of detention already undergone by the petitioner till now, within bracket 61 days, and the immersed circumstances pertaining to the earlier relationship between the person, earlier projected relationship between the deceased and the accused dash. He should be granted bail at this stage. Accordingly, certificate of 40,000 with one surety of the like to the satisfaction of concerned learned CJM Sri Bhumi, subject to the following conditions. Number 1, he shall be available for the trial upon commences. Number 2, he shall not hamper or tamper with evidence. He shall not try to influence witnesses. Number 3, he shall not in any manner harm or harass the informant and his family members. Violation of the bill entail cancellation of the bill, return by the case.
Malik, to the satisfaction of this session just Tribhumi.
It's already committed.
Yes, they are now it is in the committal court. It has been, oh, yes, committed matter, yes. But then CJM it will go.
CJM, I've seen
CJM
concerned learned court, I say usually.
Yes.
So
Learned court
within bracket CJM Sribhumi. They will
Sribhumi.
send it.
Oblige, madam. Deep
If it is committed in the meantime, it will be sent.
List 1. List 1. Sir.
Production list 1.
Oh my lord, this is was
Same FIR.
yesterday, my lord. He has also 159 days today, my lord. Abdul Muni, my lord. My lord, there is no material, my lord. What happened, my lord? The allegation is that his husband, the informant husband, went to fishing, catch fish, my lord, and thereafter he did not return. Then one day ahead of this incident, there was a quarrel between the informant's husband and the accused, my lord. And when out of that there's a suspect that the accused might be involved in the killing of my, and my lord, your lordship, my file, that out of 7 witnesses, none of have, I have annexed the judgment, 161 statement, my lord, and nobody has implicated me. And moreover, the medical report also said that they could not reach to the conclusion as to how the death was caused.
Okay, just a minute. Let me see the FIR once.
FIR, I take your lordship.
I'll go through it.
Yes, kindly. FIR is page 13, my lord.
Yeah, phone.
It is respectfully submitted that 25/4/25 at about 9:30 p.m., my husband went out our house to catch fish from the river, but till the next day morning, he did not return. As such, my husband's elder brother's daughters, namely Ravina Begum and my husband's elder brother Babur Ali, had started to search my husband and found my husband lying dead near Rani Bill. His entire body was full of injuries and his head was also having cut injuries. That about 11 above the name accused person is dangerous character, cheated. I and the accused person were studying in the GC college since 2006 and we are known to each other. By the way, we have developed relationship and our affairs started and accused used to visit my house often. That on 26/4/25 at about 11 am, I had identified the dead body of my husband. I therefore pray most humbly that your honor may take necessary action. Then, my lord, I take your lordship kindly.
I find the FIR a little peculiar. Anyway. Next, what should I see?
Then, my lord, your lordship will find page 32. Following viscera was preserved. Another cause of the death is not been. The 34, my lord. The opinion regarding the cause of the death is kept pending till report of the chemical analysis comes. Number 34. Then, my lord, your lordship will find 35. That for 35 has come to the conclusion that
there is no. They have sent a viscera for
yes,
to test for poison, but apparently the death seems to be caused by due to injuries.
But that is not mentioned here even.
Let the case diary be confirmed.
What is the 157 days I am behind the bar, my lord? 58 days today.
So this has to has to be seen, right?
And my lord, I have
not complete. Not
yes,
complete.
not complete. I have given the witness name of the witnesses, my lord.
157 days if he has completed, then we have to search it matter submitted, my lord.
Then no diary has to be seen because
Yes.
where is his name in the FIR?
His name is in the FIR is there. They suspect that they might have killed me.
We are known to each other for since.
Yeah, that is their good relationship.
Let the case diary be
And we have
confirmed.
developed a relationship and accused used to visit my husband often.
Yes. But one
Search it must have submitted, my lord. So let the
even if such a 157 days, my lord, your lordship just granted a bail. Kindly, I will face that. When medical evidence comes and chemical report comes that there is no
the case that you scan copy, my lord. If it is searched, that my lord, scan copy may be confirmed, my lord.
158 days, my lord, thereafter you will call for the charge sheet, the scan copy. I can face the trial, my lord,
It's
if
a
he is
case
charged.
of murder, my lord.
A murder, yes, it is suspected murder. Suspected murder. My lord, moreover, my lord, I have given the name, evidence of the witnesses, my lord. Your lordship will find, my lord.
No issues, man. The Sessions case has been registered. Then
Yes.
Search it.
Search it. No, scan copy may be called for, my lord.
Search it. But we don't know.
Because he has been named in the FIR, my lord. What are the materials
We
against him?
don't know anything. In fact.
FIR, they suspect that.
The,
Now it is no longer suspect,
yes,
my lord.
yes,
Search it submitted.
the accused was arrested in connection with what is this PS case? Aliganj.
My lord, charge sheet has been submitted. Page 25.
Karimganj PS case number 205
Yes.
of 2025, registered on the basis of an FIR dated 1/5/2025 regarding the missing of the informant's husband and his subsequent and subsequent recovery of his dead body. Full stop. The accused is named in a FIR. Stop. The learned counsel. The case has been, it appears that the case has been charged sheet and resulting in registration of Sessions case number 204 of 2025. The section 1031, pending before learned additional sessions as Tripum. The learned counsel submit that considering the length of detention, the accused may be granted bail. The learned additional PP submits that scanned copy may be perused. Despite the length of detention, considering the nature of the allegation and the fact that it is a case of alleged homicide, therefore, perusal of the some more materials is necessary. Would you like to approach the trial court? That is also one option.
The trial court has rejected it.
Sorry,
Reject-
That is 9-10-25, my lord, 7-11-25. Peruse it, my lord, page 25.
Okay, then it's no issue.
Only found that there, because of charge sheet, bail
Scan
was
copy has
rejected.
been received.
Receive, my lord.
Note is there.
Then, my lord, we'll peruse the screen copy, my lord. Lordship,
Yes,
if you can-
No problem.
Mother,
Problem-
Monday, my lord.
Problem solved.
Yes, Monday.
लिखा है। Can copy, but probably it has not come into the record. As per office note dated 6/12/25, it is not live office. 6/12/25, scan copy of TCR has been received. The same may be put up with the case record
Monday, my lord.
tomorrow. Oh, it's here.
Monday, my lord, because
It's here. Yeah. So after you see it, we can take up whether you want it Monday.
Monday, my lord, we'll go to the scan copy of the record.
But Monday I will not be available. I have to.
As per your convenient date, my lord, you want.
Station. I'm going.
When
It
will you be
before
here?
Another bench. No problem.
Yeah,
That's why I have narrated. This will help. Doesn't matter. It's not. It's not my previous rejection. Man,
Monday, your lordship will not be available, my lord.
no, it's not. We come before another. That's why I've written. Will be
But as per your lordship, convenient date may be you. When you will be available?
No. You are agreed by length also. Either tomorrow or then
Tomorrow, my lord, kindly, tomorrow.
Tomorrow, will you be able to manage?
If possible,
There are several cases already.
And we have a-
This has already come.
We have a truncated day also because
It
of
is,
reference. Former Chief Justice.
Monday, but I'm only praying for one day.
Give it for month. Okay. Then this narration, that's why it will help.
Monday.
Preference to
May I please, your lordship, this is regular bail application, my lord. In this case, what happened, my lord? Notice has been served under section 488 BNS, my lord. The person, he is not the family member, friends or nominated person, my lord, of the petitioner, my lord. In this regard, my lord, another matter, my lord, 2 accused matter, item number 7, my lord, of today's list. Your lordship has already been fixed the matter on Monday, my lord, and report was called for from the IO in this regard, my lord.
Report.
Yes, my lord. Item number 7, my lord.
Report or case diary.
My lord.
Is there?
CD is called from it.
BA 4002 2025.
Let us pass the same order. then.
BA given.
BA
You're-
4002.
You're Mr. Ali,
J. Ali, my lord.
J. Ali, Learned Counsel. A call for the case diary of Hathigaon PS case number 209 of 25. So you were arrested on same day you was arrested.
Yes, my lord.
2/12,
Same forwarding him.
2025. List on Monday. Just fixed on Monday.
Monday, Monday.
Yes, my lord. Monday.
List of Monday. List on 15/12 along with
BA number 4002 2025. I'm obliged. with it.
bail hearing 27.
just go quickly. Let go in a bail in okay, then after we can start. Yeah, it was fixed at 2 o'clock. It was fixed at 2 o'clock. Let us fix the bail, then we'll, I think admission more tough.
My lord,
Yes, tell me.
my lord, item number 27, my lord, up to that case diary was called for, my lord, that officer.
My lord, this case is pending since, my lord, 2014. Lordship will kindly for initial 2024, my lord.
Initially, interim was granted on 7/11/2024.
This is the problem, you know.
My lord.
See,
So lordship may kindly.
7/11.
7/11, my lord.
If it
Lordship
was
will
called
make
and
my,
sent back, then it's another matter.
my lord.
Case diary had come, yes.
Yes, that come, my lord, but it was sent back
Sent
for
back.
up to date.
Sent back.
Lordship will kindly, my lord, make my bail absolute. I will appear, my lord, whenever necessary before the IO as if charge seated, my lord.
One
before
more
the
charge
trial.
may be granted, my lord, because already is that called for.
Yeah,
Because 7/11/2024, the first order.
case diary is not received today. The petitioner was granted interim bail while calling for the case diary on 7/11/24.
My lord.
And whereafter the case diary was received, but it was not updated, therefore it was returned back for updating stuff. However, it appears that the case diary has not been received thereafter. Case diary. Again, it was received. Again, it was sent back.
My lord. Well, allegation is this, my lord. He being the chairperson of Rani Pupuri VCDC, my lord. My lord, one house was allotted to a lady. He subsequently diverted that house to another lady, my lord. Page 9 is the FI, my lord.
Page 9.
9, my lord.
Issue reminder for the case diary, the interim granted by order. Don't write even the order. I feel ashamed to write that it was granted on, you know,
But my lord, the money.
1 year, yes, you know,
My lord.
because we don't.
Last chance, my lord. It's the last chance.
No, that last chance creates its own problems. You'll tie yourself in old knots. It'll create another vested
No, my lord,
interest.
we have to verify, my lord, whether
Yes.
investigation is
What is
pending or
the
not. Otherwise,
thing?
my lord will make him a,
Yes.
is absolute.
My lord, page 18, money has already been returned, my lord, by that lady.
Today only I'll make it. Should I?
My lord, later one more chance, since my lord, the updated city has been called for, my lord. We do not know what is the investigation, my lord.
That
Progress of
is
the
right, that is
investigation.
right. Once interim is granted, it has to be decided quickly. Unless
And he has
there's
submitted, my lord, the money has been returned, my lord. That will be clear from
Page
the case diary
18,
also.
page 18, my lord.
money has been returned.
My lord, page 18, lordship will kindly see. This Habiza Khatun, house allotted in favor of the grandmother of the informant was allotted to Habiza Khatun. This is the letter by the office, block development officer, whereby she was asked to return back the first installment of 32,000. And accordingly, next page, lordship will find that she accordingly deposited that amount.
The case arose out of FIR dated 10/10/24 with the allegation that with regard to allotment of house, the sanction amount has been illegally put in the account of the co-villager Habiza Khatun rather than the petitioner, though she was entitled to the same. Full stop. The learned petitioner counsel has drawn my attention to a letter dated 18/10/24 written by the BDO to the said Habiza Khatun, informing her about the wrong credit of the amount into her account and asking her to return the same. Though case diary was called was called earlier, but was returned back for updation, and the bail petition has been pending for a considerable time. In terms of the principles in this regard laid down by the Honorable Supreme Court, I'm not inclined to keep it pending. Accordingly, the interim bail granted by the order dated so and so is hereby made absolute, subject to the condition that he shall cooperate with the investigation. It is still continuing. Number 2, he shall be available for trial if one commences. He shall not hamper or tamper the bail petition stands allowed and disposed of on the aforesaid.
I am deeply obliged, man. Obliged.
Should I record your objection?
Yes, but that's
Additional
one, my lord, my prayer to call
Objects,
for one more chance,
objects
my lord.
for the grant of bail at this stage and pray and seeks some more time to get the case there.
Public.
Then clear.
29.
This matter, Lordship, after that case, there was call for Lordship.
So it's very fine.
My lord, in this case, my lord, up to this case, there will be required, my lord. So it is not up to date, my lord.
Case diary has been received, but it needs to be updated as submitted by the learned additional people. May be sent back and procured again after incorporating the up-to-date investigation. Full stop. Interim bail shall continue in the interim granted on 5/6. Granted by order dated 5/6/2025 shall stand extended till the next date of listing.
22/1/2023.
22/1/2026.
May I please, Your Honor?
Mm.
My lord, in this case, interim protection was granted to the petitioners, and pursuant to that, my lord, they appeared before the IO and got their statement recorded, my lord. And in the meantime, my lord, charge sheet has been submitted in this case.
Is it?
Earlier, my lord, the petitioners approached this honorable court against a zero FIR, my lord. Subsequently, the FIR was registered and accordingly interim was granted, and we appeared before the IO, my lord, and got our statement recorded, my lord. And so far as the FIR is concerned, I have brought it on record by my lord additional affidavit, my lord. And the result of the FIR says that, my lord, the section incorporated in this case is that, my lord, section 296, 351, 79 and 85, my lord. Basically the 498A, my lord. And some allegation of torture and harassment, etc.
You have for the informant.
Since the charge sheet has been submitted, my lord, may I pray, my lord, that my lord, that the petitioner be appeared before the trial court.
Will do, my lord.
Press bail bonds.
My lord, will do. my lord.
Sagarikatas. Interim of grant. 1/8/2020.
That case, my lord,
A. Ali.
may I submit one thing?
Yes.
My lord, that the petition number 2, she is a divorcee now, my lord. But in fact, while filing the petition, my lord, inadvertently she has been shown as the wife of her husband, my lord. But subsequently, decree of divorce was, my lord, granted. Therefore, I have filed one, my lord, additional affidavit, so that I may not be my name may not be reflected as wife of Professor Haloy. Instead, my lord, my father's name may kindly be put. Yes, my lord.
And then we taken the. Let him.
The petitioner side has filed an additional affidavit. Bringing on record fact that in the meantime, the marriage of petitioner number 2, right?
My lord.
Joba Haloy,
My lord.
with the informant,
No, my lord. With her husband.
with her husband, has been
Namely,
dissolved
Professor Haloy.
by a decree of the family court.
My lord.
Petitioners they were granted interim bail on 1/8/2025. It is submitted by the learned prosecution that in the meantime, investigation is also completed, resulting, however, in a charge sheet. In view of the above, the interim bail is hereby made absolute, subject to the condition.
There is no interim affidavit.
Interim is there.
Yes, my lord. In both
Subject to the
cases.
condition that they shall be available for the trial and shall appear before the learned court below on the concerned dates. Hamper. Devashish Haloy. So it's written here only. Same name. This is for, so this is
1852, my lord.
1852 is for?
Milord, because two FIRs were initially, Milord, lodged before the all women police station, Milord. Subsequently, Milord, it was transferred to Aminga police station. So therefore, I came up with two petitions,
Two petitions.
my lord.
So in a way, this is same order.
The original case was that the all women police.
Oh.
That was-
The jurisdiction called it not.
Therefore,
It is not got. Okay.
Do we need to pass any order in this second one? The same order?
because since it is pending, Milord, therefore, Milord, I think an order, because
But with regard to the same PS, same person, two orders will be odd. What is this PS case?
Not what it is.
That is also not Guwahati.
no, Milord.
All
One is
women's police station.
Not
All
Guwahati.
women's.
It will not.
1850 is for all women police.
Same order. Not-
An interim order in that case was granted on 13/8, Milord, not 1/8.
13.
13/8.
Itu Pelagam. Allowed and disposed.
I'm obliged, Milord.
Eight pieces, Your Lordship. Lordship, earlier interim granted, Lordship. FR is on page 12.
At 12,
Page 12, Lordship. Page 12 is the type translated copy. Lordship, the FR has been filed by the wife, Lordship, against the family members of her husband and her husband.
kicked out of the house for the allegations. Darius,
Madam, we have received the case there, Madam. Madam, earlier, Madam, 35T notice was issued to them, Madam. So pursuant to that notice, Madam, they have already appeared before the IO and Madam, they have also recorded their statement. My humble submission, Madam, custody and interrogation may not be necessary to that is.
very fair. Very- 483 bail application. Four 82 bail application. जो PS case number 412 of 2025. The petitioner number one is stated to be the husband. No?
Yes, Lordship, husband.
Husband of the informant, and the other petitioners are his family members. The allegation in the FIR dated 29/9/2025 is about commission of cruelty, harassment, and demand of money. And it is also alleged that due to inability to fulfill demands, accused persons assaulted the informant and drove her out of the house along with her son and daughter. Apparently, it's quite serious. Quite serious. The investigation, the case diary has been received. Learned additional PP has fairly submitted that pursuant to a notice on the 35(3) BNSS, the petitioners appeared and their statements have been recorded. They were granted interim order.
Yes, Lordship. Interim was granted on
Well,
28/10/20.
granted interim bail on 28/10/2025. In view of the cooperation rendered by the petitioners, and also keeping in mind the spirit of the provision under section 35(3) BNSS dash I deem it proper to the interim by 28/10 is hereby made absolute, subject however to the condition that the petitioners shall not in any manner commit any cruelty, harassment, or torture upon the informant and her informant and her children. Number two, the petitioners, especially the petitioner shall strive for matrimonial reconciliation, matrimonial and family reconciliation. They shall not hamper or temporary defense.
Obliged.
Send back with case diary.
Keep your
33.
It is said, my lord, the CD has already been received, my lord, only my lord, the postmortem report was as called for that has not been received, my lord. If it is, my lord, you was granted by P.S. Bell by the interim order, my lord, passed on 21/10/2025, my lord. Yeah, actually, this postmortem report that was not very much material, my lord, for deciding this bail application, my lord. As per this case, there isn't any materials, my lord, supporting the involvement of this petitioner.
Okay, 172 is their lot. So it is in succumb to their injuries lot. So postmortem report is necessary lot.
Is it?
Lot.
It's not here.
Not received, my lord.
So we'll keep it pending and
Lordship.
the petitioner was granted interim bail by order dated 31/10/2025. The learned additional 50 submits that though the case diary has been received, but the PM report is not yet not available. Considering the nature of the allegations, perusal of the PM report may be necessary. Accordingly, you will keep the case diary.
No, lot.
No, the last order that was recorded. Yes, there hasn't been.
Keep it. It appears that the statement of the petitioner has also been recorded pursuant to grant of interim bail. The case diary shall be retained and requisition may be sent for the PM report. PM report. Full stop. The interim bail stands extended till the next date of listing. List after the petition on
Lordship on 7.
7.
7 January.
7. 7/1.
Yes, Lordship. Up to that case diary was called for. Up to that case diary.
Your lordship, the case is that this person lordship, the victim has a shop lordship, and this the petitioner is a
Driver.
customer lordship to that shop, and he used to come to that place lordship, and in between them their communication they grew up lordship, and they used to talk to each other, and this person as per the things lordship CD also, that this person lordship, the accused person threatened her and tried to get the obscene photograph lordship, naked photos, and he has made viral and also demand money lordship.
Actually, Honor, there
On
is a
that.
love affairs and due to good relationship, the informant brought an amount of rupees 16,000 from the petitioner on 6th May 2025 and promised to return the said money within 20 days. After 20 days, the petitioner asked his money, and in this regard, quarrel was started, and then the lady threatening the petitioner to implicate him in a false claim. And on grounds of quarrel, the facts have been converted into a story of concocted extortion just to harass the petitioner, including his family members.
However,
That's
the
it.
statement of the husband of the victim is also
Lordship.
there. He also stated the same thing in the FIR lot.
Lordship, the IO of the case must ample time to investigate the case and the investigation must progress, and at this stage, there is no need to custodial integration of the petitioner. They are having minor children and exam are going. So kindly consider his bail.
164 is there.
164, I have not found, Lordship.
Lordship, on any condition I may be allowed to go on bail, I will appear the IO.
Anticipatory bail in connection with Numaligarh rural PS case number 72 of the Nuclear section. Stop. The case diary has been received. Relevant portions. See, appears. Full stop.
But this is earlier rejected or not?
Rejected. By this court.
This court, Lord.
This court. Will be stating that investigation is not yet completed.
An earlier bail petition. This is a subsequent bail petition, as an earlier bail petition was rejected on 16/10/2025. Passed in AB 227. 2 and 3 to get big. The updated case diary has been received. Stop. Investigation is still in progress. Stop. The up-to-date materials in the case diary indicate electronic evidence containing vulnerable photographs of the alleged victim. And there is also indicative of such photographs being made viral. So, as per the allegation in the FIR, the accused is stated to have blackmailed the victim and extorted money from her. The alleged conduct of the petitioner which also finds support prima facie from the investigation would not justify granting the privilege of anticipatory bail, and therefore the instant bail petition stands rejected, and this petition also stands rejected. It's returned like the case.
May I please, Your Lord? My Lord, here, my Lord, with all respect, my Lord, regarding a plot of land,
Mhm.
the accused person are owners, my Lord. And the first informant, he entered into an agreement and paid 3,50,000 rupees. The entire consideration is 11 lakh rupees, my Lord. Even sale permission has not been applied for. We have annexed the agreement. There it has been said, my Lord, the entire amount has to be paid prior to registration, my Lord. And FIR, apparent, my Lord, as I have said, 3,50,000 has been paid. He can go for specific performance, but not criminal prosecution, my Lord. May I just read the FIR that occurs at page 18, my Lord?
Yes, page 18.
18, my Lord. With all respect, my Lord. Page,
Vernacular is that.
sorry, I'm sorry, my English is
You want to, as per your choice, whatever you want to
Yeah.
read. The translated says,
Ofomia is in 18, my Lord.
yes, one is at 11.
Yeah, exactly, my Lord.
Whatever you.
Translation, I'm sorry, my Lord. Translation is at page 11, my Lord.
I found.
If it is read in totality, my Lord, 3,50,000 has been paid. Now, what the man has done, my Lord, the buyer, Alice buyer, my Lord, with all respect, my Lord, that we have stated in page 4, para 5, 6 and 7, my Lord. He has intended and tried to construct walls, my Lord, and then I'll come to the agreement, my Lord. There cannot be criminal prosecution, my Lord. I know, Pastoli. Page 4, my Lord. if 5 is read, my lord, we have stated our part of the story, my lord. Thereafter 6, my lord. And continues, my lord. That, my lord, money was paid 3,50,000. The rest amount has not been paid. He enters and we intending to construct a wall there, my lord. That is the bone of contention, my lord. Even the sale permission has not been applied for, and he has not stated that in the first information report because he has to jointly sign it, my lord, after payment of the amount. And let me come to the agreement, and that the relevant part of the agreement that occurs at page 20, my lord. Yeah, page 22. Page 20 it begins, my lord. Annexure 2, lordship may have found, my lord. There, my lord, it occurs. Kindly see, my lord, 1. Consideration, lordship may have found, my lord. Consideration, my lord. The sale price of the said property is fixed at rupees 11 lakh. And on the date of agreement, only 2 lakh was paid. We also agree, my lord, thereafter 1,50,000 was paid, my lord, meaning thereby 3,50,000. 650 are yet to be paid. Only buyer name so and so, so and so. Thereafter, last line, my lord, the buyer shall pay the seller the balance sale price of rupees 11 lakh before registration of the sale deed. Have I made my position clear, my lord? Even, my lord, cause of action has not arisen at criminal for next, my lord, position. The seller agrees to hand over vacant position of the property to the buyer upon full payment of the. Have I made my position clear?
Yes.
On 350, my lord.
And execution of the sale deed.
Exactly, my lord. So, my lord, can there be criminal prosecution, my lord?
Terry? Lordship, I only want to focus only one point, Lordship. Yes, it is true, Lordship. There is an agreement and it is all there in the agreement. I will not talk on that point, Lordship. I will only want to two things, Lordship. In the FIR, in page number 11, may I read, Lordship? Few lines. And that has been reflected in the CD, Lordship. It has been given evidence, Lordship. That line, the accused now, 11 page, accused now on 12. Pressurizing me to return the original agreement copy and threatening me in different ways. And so, Lordship. And in the middle, Lordship, I was on duty at hospital. Both accused persons called me outside and took me to the roadside, where they threatened that I did not return the said agreement copy. They would have to be abducted. My criminal group kill me and so, Lordship. Regarding that, I have phlegma. What are there?
Assuming, if he is correct, my lord, then what section of law would be attributed, my lord?
Just go through the FIR from the beginning. Here, I'll.
It is to be read in totality, my lord, with all respect.
Just a-
What will the key? It will be. If criminal intimidation is there also, my lord, assuming true, but definitely untrue, my lord, he doesn't say one thing that he has not paid the entire amount. My lord.
This might be criminal intimidation.
And that is, my lord,
Available offense.
And
non-court bailable.
statements are also there, Lordship. Witnesses statement are also there. That part, Lordship, regarding that threatening part, he called outside the gate.
Threatening would be non-cognizable offenses, my lord. Assuming true.
Subsequent contact is not good, but basically.
So it is not only the civil case, Lordship. I want to focus on that.
Yes.
It is not only a civil case.
My lord, he
Not
may
a
be
civil
correct, but if criminal prosecution is there, my lord, on that second part of it, my lord, with all respect, my lord, he has to come with clean hands that I have paid the entire amount. The 316 and all those sections would not be applicable, my lord, with all respect.
He wants his advance back, right? That is the dispute.
My lord, exactly.
He wants his advance back.
My lord, exactly, my lord. I'll not sell the land to him, my lord.
And he's not giving back the advance.
My lord, my lord. If he pays the money, we'll register it. That may be in the order sheet, my lord, if granted, my lord. If he pays the entire amount. Otherwise, we'll pay him back the amount, my lord.
Agreement was with Abida.
My lord, my wife. Wife, my lord. That occurs at page 20, my lord.
Yes.
There can be prosecution under specific relief act, my lord.
Agreement was between husband and wife.
My lord, my lord. Oh,
Informant's wife.
Hmm?
Informant's wife.
Informant's wife. Shafiqul Haq is the petitioner, one of the petitioners.
Petitioner's wife and, my lord, informant's wife. My lord.
Petitioner's wife and the informant's wife. No. One is a male. Shafiqul Haq is the petitioner. Shafiqul Haq is one of the accused.
Accused.
Informant's wife.
Accused or informant or wife. Oh, sorry, মই কিবা উল্টা কথা কৈছো.
Invoking 482 BNSS, the two petitioners are seeking anticipatory bail in connection with Bilasi Para PS case 360 of 25. That's so and so section. The case arose out of an FIR dated and Azahar dated 11/11/25 lodged by informant Dr. Rafiqul Islam Talukdar with the allegation that with regard to purchase of a land of value at a sale price of rupees 11 lakhs in the name of his wife from the petitioner number 1. He paid rupees 2 lakhs as advance and subsequently paid 1.5 lakhs more. And the petitioner number 1 was to execute the sale bearing all expenses. But it is alleged that, however, the petitioner number 1 and 2 have reneged, reneged from this, the promise of execution of the sale and trying to misappropriate the advance amount. And when he asked for the same, he was even threatened with harm to his body. Both the petitioners are named in the FIR. Mr. Mahajan, learned counsel has drawn my attention to Annexure 2, which is a agreement for sale dated 19/4/2025 between the petitioner number 1 and Abida Sultana, stated to be the wife of the informant. It mentions about the agreement for purchase of the land with sale value, with sale price fixed at rupees 11 lakhs, and also mentions about the advance amount of rupees 2 lakhs and the responsibility of the owner to register the same. Learned additional PP, after receiving the case diary, has submitted that though the matter might have arisen out of a civil dispute, but it has a another dimension as well, and that he has drawn my attention to WhatsApp messages which lend support to the allegation of criminal intimidation. It is well settled that it is well settled that a dispute between parties might have both a civil dimension and a criminal dimension. However, the Honorable Apex Court in various decisions has attempted to discourage criminalization of what are essentially civil disputes. Full stop. Next paragraph. At the same time, if a civil transaction gives rise to offenses under criminal law, naturally the criminal law has to take its own course. In the instant case, the dispute the essential dispute appears to be is prima facie civil. However, if the materials if the materials are accepted on their face value, the subsequent conduct of the petitioners might prima facie give rise to an offense of criminal intimidation. Nevertheless, I am of the considered view that granting of anticipatory bail may not prejudice investigation. Full stop. In such view of the matter, subject to suitable conditions, provided it is done so with suitable conditions. In such view of the matter, it is directed that in the event of arrest of the petitioners in connection with this case, 30,000 with one security to the satisfaction of the arresting authority, subject to the conditions that: number one, they shall cooperate with remaining investigation, not hamper or tamper with evidence. Number three, they shall not in any manner intimidate, harass, or cause any harm to the informant and his family members. Expired. The parties are at liberty to settle their civil dispute if the return back the case the bail petition stands disposed of on the aforesaid terms. Allowed and disposed of. on the aforesaid.
Highly obliged, my lord. Obliged. Obliged, my lord.
May I please your lordship? Well, the case date was called for. Here, the petition number one is even student.
Not available.
There is not available. This diary is not available. Issue reminder for the same. This is the matter on.
Well, no interim here, sir. Kindly, he possible before vacation.
19 lot.
18.
18 lot.
I'm obliged.
Yes. sir.
CD not, receive lot.
Interim is there.
There is no interim, my lord.
No issue.
Earlier,
He's on interim.
no, my lord.
Same not all for the case. Same on
No, 19, my lord. 19.
18 or 19. 19.
19. I'll have lodged.
You are also not received lot.
This is a
Please, your lordship. This is a regular bail application, my lord. It is the Bihan River for the last 33 days, my lord.
diary is not complete.
It's a missing case, my lord. Actually, it is a missing case, my lord. But if I kindly see the vernacular form of the FIR at page 14, my lord. Both the, my lord, victim as well as the petitioner, the teenagers, my lord.
Anyway, get the diary. 18 or 19.
Okay.
Diary. not-
Lordship on 18.
18 or 19.
18.
18.
My pleasure, Lordship. My senior is in court number 18, Lordship. That may be passed over for 10.
May I please your lordship?
52.
My lord, 483 application, my lord, FIR at page 11, my lord. This case, my lord, charge sheet has been submitted and the case is in evidence stage, my lord. One witness has been examined, the informant has been examined, my lord. FIR at page 11, my lord, in this case, the allegation is that, my lord, one Bodir Ali, he has been found dead at night, my lord. And in the morning, his wife and son give the information to the villagers. And the villagers came and found that some strangulation mark is present in the neck of the deceased, my lord. And in this case, my lord, 4 numbers of accused has been arrested, my lord. The wife is arrested. The wife of the deceased is arrested. His son is arrested. And his son's friend, that is the petitioner before your lordship, he has been arrested.
and one deceased friend, he is also arrested. My lord, the allegation against the present petitioner, your lordship, that in the FIR it is alleged that he has some illicit relationship with the deceased wife, my lord. This is the allegation in the FIR. And my lord, kindly may peruse the PW1. He is the informant, the brother of the deceased, my lord. In the PW, my lord, the allegation is that page 34, my lord. Page 34, para number 6. This line is against the petitioner only, my lord. On the accused, one of the accused is Nekib Ali, who worked as painter, and he has access to home of deceased. My lord, the deceased son is my friend, and we works together. Therefore, sometimes I used to visit his house, my lord.
Per se, this is not.
Nothing else, my lord.
No, only this statement is not, cannot be. If in context, it may be.
My lord. So this is the informant says that I have access. Otherwise, except this, my lord, nothing found against me, my lord. My involvement is not there in the incident, and the rest are my lord in the CD may be fine.
My lord, scan copy has come, my lord. I have perused the scan copy, my lord. In this case, my lord, search is framed, my lord, under section 103 T5 of BNS, my lord, 26/3/2025, my lord. And on 11/8/2025, PW1 examined, my lord. So that, my lord, learned friend has already annexed with the bail application, my lord. And it is, I have also found, my lord, in the scan copy of the record. Now, my lord, as far as my lord, other materials are concerned, my lord, there are some 183 statement, my lord, that I have tagged it, my lord. Which you may kindly peruse, my lord. The scan copy.
Complex. Anyway,
There are also 161 statement, my lord, that also I have taken.
suspicions. No doubt. But the
suspicion, my lord.
trial has to emerge. But states we
Yes.
can consider.
And we in one of the 183 statement, my lord, the wife of the my lord, deceased, my lord, she stated before the police that she killed she killed his her wife, husband, my lord, with the help of the other accused. That is her.
Motive? No, nothing.
My lord.
Motive? Has he stated about motive?
Motive, my lord, it is not clear
He
from the
stated-
case there.
No, her statement? Yes. Any reasons he stated? Suppose.
Her statement is, my lord, I am perused, my lord.
Hurt so and so.
Since my other witnesses are yet to be examined, my lord, so my objection may be recorded.
Well, I am not sure whether allow or not.
Yes.
Thinking. When was he arrested?
My lord, I was arrested on
Specific-
1/20/25.
No, I want specific materials against this. Here also she stated, they used to come.
In 183 statement, my lord, the wife has, one of the witnesses stated, my lord, that she has stated before the police that, my lord, she along with, my lord, the other co-accused, including her son, my lord,
No, she has stated before police.
before police.
Then complete.
Other
hearsay.
witnesses, my lord, I have flagged it, my lord. Nobody has seen, my lord. Only, my lord, they have heard some, my lord, noise, my lord. Then when they come, my lord, they found him, my lord, lying on the bed,
Mhm.
and there was a ligation mark in her neck.
Yeah, this petitioner used to come to their house.
Yes,
Friend of the
yes,
friend
yes,
of the friend of the deceased son.
yes.
Right? Friend of the deceased. son. Anyway, we don't know. We don't know. Anyway, but 483 bail application. Rongya PS case number 352 of 20. Under so and so. Full stop. The case is at the stage of trial in sessions case number 18 of 25 before the learned additional session judge Rongya. Full stop. Charge sheet was submitted on 26/3/2025. Charge was framed later.
Charge frame on, my lord, 26/3/2025.
No, that is the date of charge sheet.
Charge sheet, my lord,
No, don't write it.
Submitted on
So far,
26/3/2025.
one PW has been examined. The allegation,
11/8/2025. Charge sheet submitted on, my lord, 26/3/2025. Hard to dispute. No, my charge frame date is not, my lord, it has to be looked into.
no, I'm not writing.
Only charge sheet date is 26/3/2025.
The accused was arrested on 28/12/2024. The FIR is dated 28/12/2025 with the allegation that Badir Ali had met with his death and a strangulation mark was found on his neck, and that his son confessed that his mother killed his father by choking. It is alleged that the wife of the deceased had illegal relationship with another person, Nekiwan. It is alleged that the wife of Badir Ali and Nikib Ali jointly killed the person, killed the deceased. How to say, the scan record has been received. Here's relevant portion there. Her own statement, what she has stated.
That I have to look into.
Huh?
That I have to look into.
It is submitted by the prosecution that it has emerged from the statement of one witness that deceased wife supposedly told the police that she had killed her husband. There are also materials to indicate that the present petitioner used to visit the house of the deceased. Son been examined, son.
No, but son is the accused, man.
Son is also an accused.
Son is arrested, man.
Will not unlikely justice.
That's
It's considering the stage of the case within bracket trial and the length of detention. I allow this bail petition. The accused is hereby allowed to go on bail of rupees 40,000 with one surety of the like amount to the satisfaction of arresting authority. And subject to the condition, sorry, satisfaction of the concerned learned court, additional session judge Rongia. And subject to the following conditions, this shall be available for the remaining trial, shall not hamper or temper evidence. They shall not try to influence or intimidate witnesses. Violation will entail bail cancellation.
My lord, since my other witnesses are yet to be examined, my
The
lord, my
learned
objection may be
advocate
recorded.
submits that as other witnesses are yet to be examined, the bail may be rejected.
At least as my lord, I'm opposing.
May be rejected. What is the other one? 2053. Hold on. Oh, yes.
Obligement.
Fifty-five. 55 আছে কি?
Should we take up the hearing, which is fixed at 2? Then we will not be
This guy
able
is
to
not
touch
present.
admission then. Okay, we can come. I have another matter where petitioner in person is waiting.
45, 40.
Will you come? You can do it. Will you be able to finish in half an hour?
Half an hour. But here your lordship will remember the issue really was regarding non-compliance of section 313 CRPC, my lord, and why it has caused prejudice to the appellant, my lord.
Yes,
Because
you have told me.
two things are required.
No,
my
this
lord.
has
One
been
is
coming repeatedly, but not reached.
Not
So
been
we
fixed.
fixed at 2. So it's okay. I take it.
so, my lord, in this case,
There are 3 matters.
3 matters, my lord. And I think, my lord, all 3 of us will be taking the
I'm appealing for the next side,
46.
43.
I will kindly take up criminal item 45, criminal appeal 294 of 23. my lord.
Issue is the same.
Issue same, my lord. 45. Well, in this case, the charges were initially framed under sections 341, 354, 323, and 376 IPC. Subsequently, it was altered to 341, 354, 323, 376, and 30, section 34 was added, my lord. Eventually, the appellant herein, my lord, he was convicted under section 341, 323, and 376, and was sentenced to undergo imprisonment of 10 years, my lord, rigorous imprisonment. There are, my lord, 23 PWs in this case, 1 court witness, and, my lord, 2 DW. But I'll just give a brief breakdown, my lord, the facts, my lord. My lord, 2 boys, my lord, who are, my lord, PW3 and PW4, and the 2 victims, PW1 and PW2. But they go into a particular hilly area. There, my lord, the accusation is that the appellants in all the 3 cases, they had assaulted these PW3 and PW4, the 2 boys, and then, my lord, rape was committed on, my lord, the victims, my lord. Now, one of the things which happened, which came out during trial, which I will produce before your lordship, was that during cross-examination, it came to light that after this incident, these 2 victim boys, they were tied up in the house of the victims, the rape victims, my lord. And then they were being asked by the parents of the victims to marry the 2 victims. So it was our contention during the length of the trial that some incident might have taken place between the rape victims PW1 and PW2 and these 2 injured victims. But subsequently, to hide this aspect, my lord, this allegation of rape was leveled against the appellants, my lord. Now, during cross-examination, this thing came out. During defense evidence also, my lord, this thing came out. But the trial court took a view that if that were really the case, in that case, during the 313 examination of the appellants, they should have raised this plea. And our contention before this honorable court is that when 313 itself has not been done as is required, so the trial court could not have come up with a finding that we did not raise this plea during our 313 examination. So on account of that fact, my lord, prejudice has been caused to the appellants. And on that account, my lord, we are otherwise praying that them, because at this stage, my lord, it will also not be fair on our part to pray for an acquittal, my lord, because 313 is a vital part, as the lordship knows, of the entire trial. So if it is not properly done, it prejudices both the prosecution as well as the defense. I'll take your lordship to the judgment. First, your lordship will kindly come to the judgment. That is at starts at my lord.
But to remand back for 313, the judgment will have to be set aside.
Set aside, my lord. On that ground, limited ground, my lord, without going into the merit, my lord. At page 21, my lord, the judgment starts, my lord, in item number 45.
Well, let us see the 313 then.
313. 313, my lord, in the records, I have flag mark, my lord. There's an orange flag, my lord, in the TCR. Was it? PC.
Yes. Yes, original. Criminal appeal, we need a paper book actually.
Fine.
I'm not saying that it has to be completed within half an hour, but today we'll hear for half an hour. Because it may take more time.
I'll just point out this 313, my lord, then I'll come to the judgment, my lord. There's an orange flag, my lord. What law mandates is that each and every individual incriminating evidence has to be put to the accused so that the accused can give an answer in respect of that particular incriminating evidence. Now, your lordship will notice for each of the three appellants, my lord, what the learned trial court has done the learned trial court has reproduced the entirety of the evidence of each PW. One question for one PW. Whatever has been said by the PW in its entirety, it has been put in one question. And it has been expected of the appellants that the appellant would answer each and every incriminating evidence when the entirety of the evidence of each PW has been put to the appellant. Lordship will notice, if your lordship is taking up the 313 of the appellant, my lord, Simanto Borua, my lord.
I think without this was difficult.
On bare perusal, my lord,
It will
it
be
is
direct preparation of a paper book because this will be difficult. Because all these
The petitioners are also, appellants are also in jail for almost 3 years now, my lord.
petitions.
Depositions are all in English, my lord.
No. SME is not a problem, but the thing is that the handwriting is a bit problematic. Anyway, so you can read one of them perhaps.
My lord.
Mainly 313 part.
Big paragraphs.
It is very difficult, not at all very good. 313 part.
Yeah, would you like to argue on the full merits?
No, my lord. Our simple contention is
No, because suppose that contention is suppose the court is unable to accept that contention. Suppose the prejudice test is passed. Suppose not passed. Suppose in favor of the accused. Then I have to go into merits.
No, we'll, in that case, my lord, we'll argue on merits also because in our respectful submission, I believe, my lord, all three of us also agree that this is a case which would otherwise go for an acquittal because at the end of the day, the prosecution has to prove our guilt beyond reasonable doubt. In this case, there is question of reasonable doubt. We are otherwise submitting only on this fact that because unless and until the 313 is properly done.
There is a judgment of the Supreme Court, right? That if the question of inadequate 313 is taken up at the stage of appeal,
yes, my lord.
What is to be done?
Yes, my lord.
There are directions.
Yes, my lord. Multiple judgments are there, my lord. I've just brought a few, my lord.
Can you read one of the 313? It appears very big, actually. Yes,
My lord.
it appears big. You have to.
The lordship is
Incriminating should be short. Ideally, because each incriminating substance has to be given.
Separately given.
Some exhibit is also mentioned, but substantially, if he is able to know what is the incriminating matters, then prejudice test might come. Anyway, we'll have to see the law. It is very clearly laid down. Point wise.
Yes, my lord. In the Govind Singhal judgment, which this honorable division bench
of the
yes, my lord.
Our just
This honorable High Court division bench has clearly examined all the laws, my lord, on that point.
Govind
Singhal, my lord. That Singhal, my lord. I'll just give a copy, my lord.
Let us read one of the 313.
313, my lord. My lord is taking up the 313 of accused Simanta Borua, my lord.
Simanta Borua.
Simanta Borua is the appellant in item 45.
29/2/2020.
My lord. The first question, my lord.
First question.
যোৱা ইংৰাজী 21/7/2013 তাৰিখে দিনৰ 1 মান বজাত এই গোচৰৰ 1 নং সাক্ষীয়ে ঘৰলৈ 2 নং সাক্ষী this is the name of the victim, my lord, আহে আৰু আলোচনা মৰ্মে 1 নং সাক্ষীয়ে Teo. This is Hirok, the name of the victim, my lord, which I'm not reading out.
Help also.
Yes, Zeki Bosumotari and Hirok Jyoti Bosumotari and Hirok Jyoti. Koi. No, Hirok Jyoti Roy. Bamungao. বামুণগাঁও পাহাৰত যোৱাৰ সমস্ত খবৰ সেই ঘৰত দিনত 3 মান বজাত 1 নং সাক্ষী আৰু আদাৰ ভিক্টিম 2 নং সাক্ষীৰ ঘৰৰ পৰা চাইকেলেৰে বামুণগাঁও পাহাৰলৈ গৈ থাকাত হীৰকজ্যোতিয়ে কয় ফোন কৰি 1 নং সাক্ষীক জনায় যে তেওঁলোকৰ আৰু জেকি বসুমতাৰীয়ে বামুণগাঁও পাহাৰ পাইছে পিছত তেওঁলোকে চাৰিওজনে এটা পথেৰে ওপৰত বহি চিপছ খাই থাকোঁতে পানী পিয়া লগাত ওপৰত উঠি তাৰ পৰা পানী খাই আহি থাকোঁতে 1 নং সাক্ষীক 2জন ল'ৰাই ওপৰৰ পৰা আৰু 1জন ল'ৰাই তলৰ পৰা আহে আৰু মিলি কয় তাৰ পিছত 3জন ল'ৰাই তেওঁলোকক তাৰ পৰা আহি ল'ৰা 3জনে পাছত তেওঁলোকক চাৰিওজনক মাৰপিট কৰে 1 নং সাক্ষীক জেকি বসুমতাৰী আৰু হীৰকজ্যোতিৰ লগত সেক্সুৱেল ইণ্টাৰকোৰ্স কৰিবলৈ কয় হীৰকজ্যোতিৰ লগত PW2 হীৰকজ্যোতিৰ লগত সেক্সুৱেল ইণ্টাৰকোৰ্স কৰিবলৈ দিয়ে 1 নং সাক্ষীয়ে পাহাৰৰ পৰা নামি আহোঁতে পথাৰত কাপোৰ পিন্ধি থকা দেখা যায় আৰু 2 নং সাক্ষীয়ে মুঠতে বাইক সোধাত তাইক 2জন ল'ৰাই ৰেপ কৰি দিলে বুলি কয় তাৰ পৰা গম পাই বুলি এই গোচৰৰ 1 নং সাক্ষীয়ে শ্ৰীমতী সোয়েনসোয়ে এই গোচৰত সাক্ষী দিয়ে So this is the crux of the entire allegation of PW1. Your Lordship will kindly see the evidence of PW1, which your Lordship will find in the judgment. Lordship will kindly come to.
No, it will definitely need a paper book because some of the witness.
Well, what we can do is that, my lord, if required, we will prepare 313, my lord. The questions of the 313 and we'll
You can
submit
give it to our branch. You will prepare it next week.
Because what has otherwise happened is
Because,
your Lordship has noted.
I seek guidance of both of you, actually. So suppose it is, we stop the argument, obviously this has, judgment like this has to be reserved.
Yes, ma'am.
On this point, suppose it is, he argues on this point, and you also argue on the point of 330. Apparently, on the face of it, yes, ideally it should not be so big.
Yes,
It should be small, incriminating substance. So and so has said that you were present at the place of occurrence. What do you say?
Yes.
Then that is not, may not be fully incriminating, whatever. But the thing is that suppose that contention, I am suppose unable to accept that, okay, despite the 313 being not perfect, it has not caused prejudice and this ground is not there. Then what do I do? He has,
Definitely.
the argument has not been on,
Suppose, my
argument
lord,
has not been on,
Yes,
this
yes.
thing,
Suppose,
on
my lord,
merits.
in case, my lord, your lordship, my lord, accepts the argument advanced by my learned friend, then your lordship will have to definitely remand back only
Set
to
aside the
decide,
judgment.
only to
Remand
decide
back.
on the point of 313.
No, no,
Okay.
313, remand back. There will
Remand.
be a new judgment.
Yes, definitely, my lord, a new judgment, again,
New
fresh judgment will need to be passed. My
Yes, but no, I'm not, that is there.
Yeah.
What I mean to say is that suppose that contention that it should be, that only 313 aspect is argued, right? That 313 is, has caused prejudice, it has not been taken properly, should be remanded back to be, from that stage.
Yes.
for fresh 330.
330.
Even then, it will be set aside and return back for a fresh 330, fresh judgment. But suppose after that argument, when I write the judgment, suppose I find that only on 313 it need not be set aside.
Yes.
Then I'll get stuck because it has not been argued on merits.
My lord can then fix it.
Then, my
and
lord,
come up, whatever come up as to be spoken to, and then your lordship may ask us to argue on merits, my lord.
Yes.
If your lordship is
spoken
not
to.
there.
Then, my lord, I
Of
will
course, that
also
option
have
is
to.
always there.
Yeah.
That option is always there.
My lord, we in our respective submission, we can always argue on merit in this case. I believe, my lord, we have a case on merit
That
also.
will be better, I think.
But
Spoken to.
Otherwise, my lord, first, while they are taking the, my lord, argument only on the basis of 313, first point, they will have to, my lord, satisfy your lordship how they are prejudice, my lord. Actual prejudice, how, my lord, that, my lord, not
Then
record,
we have to
not recording that
well defined, lot of that's very, it has been summarized.
Yes, yes,
What is exactly to be done,
yes.
isn't it?
the law otherwise has been laid down very clearly. That these two
It's a
things are
leading
required.
case, I think.
Otherwise,
Not-
for consideration,
Not leading case.
Two things are required, my lord. One thing is that each and every incriminating material has to be put to the accused. And secondly, long and verbose questions, they are not to be put to the accused.
But will it be fatal, suppose if it is put? That is the.
There is a criteria on that also, my lord.
otherwise, my lord, my argument, if my lord, your lordship will discuss the merits of the case. Otherwise, from the merits, there are witnesses. There are, my lord, know that my point of view is that
It is a it's a heavy matter.
heavy matter because
Witnesses also long, 23 witnesses. All the three like convicts have filed separate.
Separate replacement. One has not been convicted under 376.
otherwise,
Two have been convicted under 376.
And they are in custody.
One is out on bail. Ours are in custody for almost 3 years now.
Accused number 1 and
We cannot.
otherwise, my lord, from the other materials, yes, there are, my lord, my lord, prosecution has proved beyond reasonable doubt, my lord, there is no doubt.
That is, I have not argued on that. My
On
lord.
that.
Beyond reasonable doubt, it has also not been proved.
Have a look and just give me
No,
give me 2 minutes.
Might well just see the judgment for once. My lord.
Just give me 2 minutes because I'm just seeing whether. The incident is of long back, 13.
2013, my lord.
2013.
Therefore, we need to.
They've been in jail, my lord, since
First in the year.
The later parts of the witness depositions are typed. All the previous parts till PW 16 till PW 15, they are all in handwritten.
But in the judgment, my lord, everything has been reproduced.
But the cross check has to be done. I think paper book will
Yes,
be paper book. Without paper book, it will be difficult. Or maybe another bench, just with better skills. But
only conviction is for 10 years, your lordship.
paper book will always be
Better go
desirable.
for another bench, then also, my lord, paper would be required
Yeah,
because
paper-
the 313 statements are not at all legible.
313 to will need. They can also help maybe. But
So, my lord, if your lordship permits, my lord, we'll translate everything and produce
then
it to this honorable court.
there's a procedure like that also. No? They check again and then they do something. Isn't it? Something of that sort they do.
Because, my lord, once it goes for preparation of paper book, it will take around 3 to 6 months, my lord.
Is it?
My lord. Generally, it takes, my lord. Unless, of course, my lord, we prepare it.
Then another bench.
Because trial court gave a very clear finding on in para 51.
No, because it has to be while preparing judgment. Because I first appellate court, right? Complete facts have to be gone into again. Depositions have to be gone into again. And he is also right. This 313 is it's. Are you comfortable reading this?
No, I am not at all comfortable.
No, you are.
In fact, my lord,
You're much more strong.
yes, but
in fact,
then also, my lord, I myself, my lord, verified that it's not at all legible. So I
much
find it-
strong. No comparison.
yes,
So it's nobody's fault actually. No, but the handwriting is.
In that case, my lord, may we submit one thing?
Mm.
The lordship will fix a date immediately after the Bihu vacations, not now. You know. So it will give ample time to the translation branch, my lord. they can prepare the paper book and have it put up, my lord.
The branch.
My lord.
Yes, yes. After the verification.
After verification.
In Arunachal, I came across excellent paper. Of course, there are lesser cases. Excellent paper. But here, so. No, what is the current practice?
Had the person been outside, my lord, there would have been no hurry. Tomorrow it goes for, my lord, if it's remanded back, then this period
True.
that he is undergoing.
You're always at liberty to file IA, but that has to be seen on.
So IA, my lord, in this case,
has to be seen
there's
on
another IA was filed, my lord, earlier it was rejected.
Rejected. Oh, can be. It depends on stage to stage, but it has to be seen properly because it's a slightly, challenging matter. Anyway, so. Till the third. Council will be different. Common or. Preliminary contention of the learned council or the convict appellant at this stage is that the examination under 313 CRPC has not been conducted in the manner it should have been, in as much as specific materials have not been put and omnibus statements from the deposition have been put to the
Not exactly omnibus, my lord, the entirety of the deposition has been
entirety
condensed
of the
into one.
deposition. Yes, well, that will be wrong expression. Entirety of the deposition has been put to the accused, and that the same has caused prejudice. It is submitted that there are also laws in connection with the same governing the matter. The learned also heard learned additional people. Yeah, upon perusing the case record, I find that for better and effective adjudication, there's need for preparation of a paper book. Full stop. Therefore, there we have the paper book section. Paper book section. Shall prepare a paper book of the deposition, paper book of the criminal epic. Expeditiously. So that the hearing can be proceeded with. It may be mentioned hearing that the except in criminal appeal number so and so, your case, right? Third one is on bail, no? Third one.
I'm the MJ Guru for 37, I think.
Yes, Utpal Roy, except for appellant Utpal Roy, the other two appellants are in jail. Are in jail serving out the sentence. This is the matter. Should we fix a date?
Fix the date, my lord.
I'm not up to date with the latest situation in our translation wing.
23rd of Jan. 21st, my lord. 21st or 22nd, my lord, January.
I think it will be more prudent to fix it on 24 or something.
Hello, as your lordship doing for
24. 24? No.
24 will
Sunday.
27th, my lord. 27th.
27.
Not on 27. I have some.
29.
29.
29.
29.
29.
Mr. Abba was himself an expert in the translation wing. He's the man to say what is the state, his colleagues.
No, 3rd of February then, my lord.
3rd of February.
For everybody.
Okay.
Hello. Deeply obliged.
Hmm. Anything urgent, because yeah, half an hour, full court meeting is also there, so. On petitioners in person is also waiting through, so I think on urgency basis, I think we should take next half an hour urgency basis.
Lordship, the
Rest, we can
item
take
for
leave
the
time.
Lordship in the
Hmm?
earlier morning, the mention Lordship. that
Which one?
PM, The delay of the condonation of the 2000.
Item 40,
40.
it was for delay condonation.
This Lordship. The maintenance principle.
Admissions are also there. Alright. Serially, that's true, serial. Admission. Four serially only.
May I please, your lordship? So other day, your lordship had already heard this matter partly, my lord, and I have already submitted two judgments, my lord. One on the point of the conditions that the
Compensation.
learned trial court should, my lord, observe, my lord, before granting this 20% compensation, my lord. And another on the point of, my lord, if, my lord, the check is not mine, my lord, what happens, my lord? Then, my lord, there is no question of any 148 proceedings, my lord. And regarding the, my lord, that the other day, my lord, my line of friend has already was said, my lord, that the check is eligible, my lord, not readable, my lord. But that is their check, my lord. And even the bank officials, my lord, that is their witness, my lord, who has, my lord, deposed before the court, my lord. Then my humble submission is that, my lord,
This was not justified at this stage.
this is not justified, my lord. I am ready to face the trial, my lord. I am not before your lordship for quashing of the entire proceedings, my lord.
Yes.
I am only for the stay of
Submitted,
this,
my lord.
and I will pay, my lord, if I am found guilty, my lord. That is my humble submission.
That's people. People go around, there's appeal, there's a revision, and it goes on. That is why these provisions have been made, actually. to
Yes, my
help
lord, but
complainants.
the
Though, as I said,
yes,
definitely to some extent it amounts to prejudging, but therefore it is prima facie. You've shown me that judgment when nicely.
my
you've
lord.
shown me, or one of you have shown me, or it's in another case. Very nicely, all these principles have been laid down. That is the leading case now on this point.
Rakesh Ranjan Srivastav, my lord.
So basically you have completed, isn't it?
My lord.
Your submission is pending. Your submission is pending. I have. Just. Okay, please, go ahead. Go ahead.
My lord, the other day, my lord, whatever submissions he made, my lord, I had replied to each and every point, my lord.
Now, quick reply to his submissions made today, my lord. He is making a submission before the court, my lord, that the check is mine. They are saying that check is theirs. From where he came to that conclusion? How can they say that the check is mine? There's nothing on record to show that the check is mine. Absolutely nothing, my lord. And again, there is a submission made that it was my submission that the check is ineligible. I said that the account number cannot be identified.
Account number.
As simple as that, my lord. Why wrong submissions, my lord? Now, my lord,
Last 4 digits are not eligible.
that much what was my submission, not the entire check.
No, you're not in.
If they take a stand that the check is mine, it has to be through cogent materials in the case record from where they should submit. Not from anywhere they will come and they will say the check is theirs. That is mine. Now, my lord, there was a registered agreement with him, my lord, for sale of a land at rupees 16 lakh, which is admitted. It is an admitted position that there was a registered agreement for sale entered between the parties, wherein it is specifically mentioned that my land is being sold to him at rupees 60 lakhs. And my lord, in that registered agreement for sale, there is a specific clause which says that if he can sell the land at a price above
Higher than
60
that,
lakhs,
That's his.
that is a registered agreement for sale, which is exhibited before the learned trial court below. And that is an admitted document, my lord, and it is a registered document registered before the sub-register office. That is not denied in this case. Again, my lord, that registered agreement for sale was cancelled again with a registered deed before the sub-register. That is also not denied. That is also admitted fact between the parties. After cancellation of that agreement for sale, 3 people were brought by him, whom I have registered the sale deed with in regard to my land. And my lord, they have paid me an amount of rupees 24 lakhs. And for 36 lakhs, he gave me 2 checks. And for that, my lord, after cancellation of the agreement for sale, there was another agreement which is notarized, signed by him and me. That is notarized agreement Exhibit 4 before the trial court, Exhibit 4, wherein he have wherein the clause specifically says that 24 lakhs is paid. For 36 lakhs, one installment will be paid on 24/2021 and another installment will be paid on 14/6/2021. These 2 dates are mentioned in the 3rd agreement between the parties, and these 2 dates are, my lords, the same date which is there in the respective checks. One check is of 24/2021 and another is 14/6/2021. At the cost of repetition, I am submitting, my lord, there were 3 agreements, 3 deeds between the parties. First, agreement for sale. Second, deed for cancellation. And third, a notarized agreement wherein the clauses are specifically there that 24 lakhs already paid, 36 lakhs he will pay me in 2 installment dated this and this. And that too, on that respective dates, these 2 checks were issued.
Cancellation was initially because he could not find buyers.
My lord.
The second deed about cancellation was because he could not find buyers.
No, because he could find buyers. In the first agreement for sale, my lord, there is a
That's
no, my lord.
You know,
In the
going to
first
the
agreement,
civil aspect of the matter. Anyway,
in the first agreement for sale, my lord, there is a specific clause which I have mentioned
Yes.
that above. Now, my lord, he arranged buyers, 3 buyers. Now, to enter into a sale deed with these 3 buyers, I have to cancel this deed. So this deed was cancelled and agreement for sale was executed in favor of those 3 buyers. Since he could bring the buyers, so I have executed.
okay.
My lord. Then, my lord, another agreement was there where it is specifically stated the 24 lakhs paid, 36 will be paid on such and such date. That is the dates on the two checks. And my lord, these all documents which I am referring, my lord, are part of LCR, my lord. It's exhibited documents.
TCR.
Yes.
Okay.
Now, my lord, there is absolutely no evidence on record, my lord, which clarifies or which shows that the checks are not his. Nothing on record, my lord, which testifies that these are not his check. This is not his check. And my lord, most importantly, the bank manager never said that the check does not belong to him. The statement of the bank manager on which they are banking, nowhere it is mentioned there that the check does not belong to him. And my lord, neither did the bank manager say that the check belonged to the lady whose bank account he brought, my lord. Out of nowhere, he brings bank account details of some lady and he is depositing before the court. And my lord, these are the facts, my lord, which needs to be appreciated by the learned trial court below, my lord. At this stage, my lord, I humbly pray, my lord, that this court may kindly not enter into those facts, my lord.
I have limited jurisdiction.
Yes, my lord. And I'll just place one judgment, my lord.
No, I cannot also.
Yes, my lord, for this.
Because it's not a petition, not even a petition, he has fairly submitted.
Yes.
It's not a petition for quashing also. Even quashing, we cannot do evidence appreciation.
Yes.
But this is, here it is only see whether the, whether the order has been passed in terms of the, parameters provided by 140, 148
Yes, yes.
and this
143A, my lord.
the judgment.
Kindly, my lord, this is Munna Devi case, my lord. One of the famous case, my lord, we always cite, my lord, 2001 9 SCC 631, para 3, my lord. Para 3, we find substance in the submission made on behalf of the appellant. The revision power under the Code of Criminal Procedure cannot be exercised in a routine and casual manner. While exercising such power, the High Court has no authority to appreciate the evidence in the manner as the trial and the appellate courts are required to do so. To do. Revisional powers cannot be exercised only when it is shown that there is legal bar against the continuance of the criminal proceedings or the framing of charge.
That's the easy situation. But
Yes.
But this will be an interlocutory order. This will, since he's filed a revision, not a criminal petition.
But this is interlocutory but final in nature.
No, yeah, you're right. Actually, this is an intermediate order. It has been said, no, that term has been used. Not us, not you, not me. Honorable Supreme Court has used that.
Yeah.
Now we have a new. We also have a category in between, as you rightly said, right expression.
Yes.
That in form interlocutory, but in substance of final nature.
Yes.
You're right.
Yes.
Interlocutory of final nature. Those orders have been referred to as intermediate orders.
Yes.
Kind of intermediate order.
Mm.
Since it involves financial liability on him,
Yeah.
then probably, therefore, he has a right to file a revision.
Yes, my lord. Now, my lord, the 20% amount which is awarded by the learned trial court below is in exercise of his powers under section 143A of the NIA. So what I mean to say is that the learned trial court has power to pass this one. Now, my lord, one check was of rupees 20 lakh, another check was of rupees 16 lakh. So total is 36 lakhs, my lord. 20% of rupees 36 lakhs is 7,20,000, my lord. Now, my lord, this may kindly be noted, my lord. The checks are of 2021. One is 24/2021 and another is 14/6/2021. Now, my lord, more than 4.5 years have already lapsed, my lord. And my lord, my land is sold. I am landless. He made profit from my land, my lord. He already made profit from my land from the sale proceeds, and which is over and above 60 lakhs. And I got only 24 lakhs from the sale proceeds, my lord. My lord, he not only kept the profit, but also he kept the sale proceeds of rupees 36 lakhs, my lord. Now, my lord, what is directed to be paid is 7,20,000. That also, my lord, after 4.5 years. After 4.5 years, my lord, I may kindly not be deprived, my lord, of this amount, my lord. My lord, I am badly in need of money. My lord, after the trial court passes its order, my lord, again it has to climb session court, my lord, appeal, then high court. Many more years to be added up, my lord. After 4.5 years of litigation, my
Out
lord,
of compulsion, these provisions have been made, 20%.
that's what, my
The
lord.
stage of appeal, and in this kind of things. Otherwise, it, to some extent, we agree that it prejudges. But out of this, it has been, if the person who had borrowed, lent money or whatever, transaction, it has to, run helter skelter, then anyway.
My-
But the parameters have to be satisfied.
My-
That is true, because otherwise he's whether his liability is being adjudicated in a trial, right? So even before that, you are putting liability on him, right? So therefore, this prima facie parameters have to be satisfied. That is the
My-
that is the.
And my lord, for that parameters also, my lord,
Otherwise, this provision will be liable to be set aside.
yes, my lord. Because, my lord, what ground they have came with before the high court, they are saying that, my lord, their primary submission, my lord, is that there was an agreement for sale. That agreement for sale is cancelled. They have no liability. So, since there is no legally enforceable debt
And the check is not there.
and the check is not theirs,
That is the main.
my lord, now how
Check
can
has
High
been
Court
stolen.
decide whether the check is his or not? For that, evidence is required, and they have brought up the evidence of a bank manager. Bank manager nowhere says that it is not his check. Moreover, my lord, in 143A, my lord, it is specifically provided that if he wins the case, I have to return the money with bank interest. That is taken care of. Already more than 4.5 years have elapsed, my lord. Neither I have my land, nor I have been paid for my land. And my lord, let not consider the check alone. Let us consider the agreements. There are 3 agreements. Exhibit 4, my lord, which is a notarized agreement, is in line with the check.
Anyway, so that's what I start a little bit.
My lord, my lord. I'll not trouble your
I
lordship.
will- You want to reply?
Just one point, my lord.
Yes. Then
My lord, if my lord, there is any liability, my lord, I am only on the checks, my lord. Check and the 20% of the compensation that has been directed to me to be paid, my lord. Only on those 2 points, my lord. If I have any liability, my lord, any other liability, my lord, for that, this is not the forum, my lord. 138 will not come, my lord, for that. If the checks are not mine, my lord, then 138 will not
yes,
come.
that's true.
Yes, my lord. He can go for money shoot, my lord.
You
There
don't-
is
you-
another provision,
You
my lord.
deny the signature also.
Yes, I deny the signature. From the very first date when I received the demand notice, my lord, I have stated, I have, this knowledge is already in him, my lord. I have replied in the demand notice that these checks are not mine. I have filed an FIR. He is out on bail, my lord. So that is my humble submission, my lord.
The mention. Sit down. No, that's no problem. Third, as far as Learned Counsel for response number 2. Should I record any prosecutor here? Burwa. State is a formal party. Who, should I record your name? RJ Burwa. No, he has not. Not necessary to make state party actually nowadays. Not necessary actually. Anyway, additional PP for this. The petitioner has filed criminal revision under section so and so, the PNs. When you under section 397-401 PNSS as the CRPC, read with section 482 CRP. Agreed by order dated passed by the learned JMFC Nalbari, whereby invoking the provisions of section 143A of the NI in order dated 26/9/2023 was the additional seat Nalbari in NI case number 59 of 21, whereby invoking 148A of the Negotiable Instruments Act within bracket herein after NI, petitioner was directed to deposit 20% of the check amount to the complainant as interim compensation. It is stated that the respondent number 2 as complainant instituted filed a complaint case under section 138 of the Act for alleged dishonor of check amount amounting to rupees 16 lakhs issued by the petitioner, resulting in the aforementioned NI case. What is the stage of that case now?
Stage is for my lord payment, my lord, now.
No, otherwise.
Otherwise, my lord, they have already examined the bank official, my lord.
It is at a stage of trial. No?
Trial, my lord.
Trial.
Right.
Full stop. I'll need the record. Record of the scan report. The the case is stated to be at the stage of trial before the learned court below, and one witness has also been examined. The order granting interim compensation was admittedly passed after the stage of plea of guilt, which was after the stage of plea of guilt, if any of the accused, to which he claimed to be tried, and offense was explained to him. This record case. The primary contention of the petitioner side is that the check in question does not belong to him, nor the account number, and that he does not even have a account in the concerned bank, that is South Indian Bank, and that as such the question of his giving a check from the said bank does not arise. Petitioner also contends and states that the signature in the check is not his signature, and that these facts have also been incorporated in a notice given to the complainant. This Mr. Parashar, the learned counsel, has taken the court to the relevant documents annexed to the petition, including the notice notice dated 2022. It is contended that the order passed by the magistrate, learned magistrate under 148A does not fulfill the stipulated requirements, as there are disputed facts which are awaiting adjudication in trial by adducing of evidence, including the aspect of the signature of the petitioner. And therefore, the revisional jurisdiction of this court may be exercised to interfere with the said order, which has prejudiced him before trial. The scanned copy of the record was called for and has been received. Mr. Khan, the learned counsel appearing for the complainant, on the other hand, submits that it has clearly emerged from the materials, including the testimony of the bankman. The account number belongs to that the account number belongs to the petitioner.
No, man.
Sorry.
He brought.
Sorry. That there was an agreement between the petitioner and the complainant regarding the sale of lands, and under which the complainant was to receive rupees 60 lakhs, and the sale of the land, if any amount obtained by the petitioner regarding such sale above that amount of 60 lakhs can be kept by him. It is submitted that subsequently, subsequently, the petitioner would arrange 3 such prospective buyers who are willing to buy the land, and in view of the same, the said aforementioned agreement was cancelled. Thereafter, the land sale agreement was entered into by the complainant with the buyers, which is that it is here in the record.
Yes.
That agreement.
Yeah.
Yes, help me with the page number. That we had seen it, no? Oh, note is there. Which was the page number? No, this agreement is here, cancellation agreement.
Cancellation is there, my lord. in the petition.
The last agreement, we had seen it.
This is first agreement is there,
Yes, this is
And-
there.
and then my lord. Check. Then exhibit 2. That is a notary agreement, my lord, after cancellation with him.
It's not in the record. Seen? Or you had just supplied like that? Did you supply just like that, or we had seen it from the record?
My lord, I have certified copy, my.
This will be necessary. Anyway, pursuant to this third deed dated ... it is contended by the complainant, learned counsel for the complaint, that with regard to the 36 lakhs,
Yeah.
36 lakhs, he paid the check.
Yes. Exhibit 2.
Have a look. We'll end it here.
It 15
Huh? I don't want to keep this actually. It's yours. I don't
Mine.
want to keep this original certificate.
This part of
It should be record. I'll see from the record. I'll see from the record. We'll just one line and close. We have to reserve because it will not be no time to complete this argument dictation. It is contended by the complainant side as respond number 2 that pursuant to this agreement, the petitioner side issued the concerned check towards part payment of the due amount. And upon its presentation before the bank, the said bounced, and as the payment was not made despite giving the statutory notice, the complainant was constrained to initiate the proceeding under section 138 of the NI Act, in which subsequently the impugn order came to granting interim compensation came to be passed. It is a
Mal.
rest. I'll reserve it, but rest of the little bit actual part. Take the mentions. Well, if not next week, then immediately on reopening, I'll get the.
My lord, may kindly observe one more thing there. My submission will record it. That first time when the check was dishonored, it was for insufficient fund, not for signature mismatch. It is there exhibited, my
It is submitted by the counsel for the complainant, respond number 2, that when the check was presented on date, it was dishonored due to insufficiency of funds.
initially. Later, due to
Signature
signature.
mismatch. I will fine tune the petition and see it again. It's like. Okay, we'll
My
go for
lord,
the
I-
mention.
I submit, beg to submit the item 18, my lord.
Grateful, man.
It was in connection with the gym of the vehicle. More than a year, the vehicle is behind the, at rotting in the police station, my lord. So any date, my lord,
Not reaching, no?
item 80, any date in the new year, my lord.
Your Lordship, after 21st, I am for the respondent DRI.
24.
21st.
Oh,
After 21st.
After 21st,
After 20.
or 18, paucity of time, list the matter on. Just a minute, excuse me. List the matter after 18,
After 21st
after 21st,
January.
Let it be 22nd.
okay, 22/1, 2026.
Yes. Your Lordship, my presence may be recorded. D. Bora for the respondents.
D. Bora appears on behalf of the respondent. Yes.
May I please, Your Lordship? Item
22/1.
May I please, Your Lordship? Item 55, Your Lordship. I am for the respondent number 2. And there
Item,
item 55, Your Lordship. Supplementary list. Bail here. I am for the R2, Your Lordship. There are serious allegations of
Okay.
violation by the petitioner, Your Lordship.
Wait, call the.
And many dates for adjournments have been taken, Your Lordship. May be kind to fix it on 18, Your Lordship.
Just. What was timing? Timing. Is there? It's received. Okay, no problem.
18th, Your Lordship.
Just a minute. Paucity of time. Case diary receipt may be retained. Mr. S. Sur,
Yes, sure, Your Lordship.
Learned Counsel for the informant. Say, how about 16?
Your Lordship, little difficulty, my personal difficulty, Your Lordship.
Okay, no problem.
18th, Your Lordship.
My duty to accommodate.
Much of
18. I am only saying if you are free
deeply obliged.
towards the
Deeply
end.
obliged.
Now,
Lordship, I beg to mention item number 42. Due to paucity of time, it could not be reached. I beg that the item be listed on Tuesday or Wednesday, Your Lordship. It's fixed for orders.
if you can manage after vacation, because next week will be
Lordship,
mostly preoccupied with the bails and some other very urgent matters on the
Your Lordship,
criminal roster.
will be a very short matter, Lordship. Any date on the next week also would do. 18 or 19 would also do.
What is the subject matter, man?
We had filed an FIR under 376. That matter was stayed and the accused was given bail. Then subsequently, they have been harassing us with complaint cases and other cases, Your Lordship. So intervention of the court is much required, Your Lordship.
Paucity of time, 16.
Much obliged, Your Lordship.
May please, Your Lordship, the item 40, Lordship.
40?
40, Lordship, on
Yeah, I almost wanted to take.
Monday, Lordship.
This was no, let it be on Tuesday.
Lordship.
Tuesday.
May I
But
please?
again, orders matter. I do not know. So Tuesday, huh? Okay.
May I please your lordship, item number 43 may kindly be listed on Thursday 18th, that is 18th.
Let it be after vacation, unless there's some very, something very urgency or something. Let it be after vacation. I don't know subject matter. After vacation,
Yes.
after list, well, on 7/1.
Yes.
7/1.
May I please,
Positive time, 7/1.
Lordship, item number 41, and in this case, Lordship, the appellant convicted under section 304 for 10 years, Lordship.
Acha.
And I don't put the Lordship, almost Lordship 1 year served, Lordship.
Acha.
Lordship, can it
Yes.
be on Monday, Lordship?
No, not, we have to wait, because this is already convicted. So many, we have to, all are important. All
Lord.
matters are important. Nothing is less important. But within that, you have to
Then Lordship, fix any date, Lordship, for Lordship.
something like that.
Convenient, Lordship.
Kindly bear with me after vacation.
Lordship. Any date, Lordship, after vacation?
Let us fix it on 9.
9.
Take a chance.
Deeply obliged.
Yeah, you have a right for every matter
Okay.
to be heard. Never feel apologetic. You have a right for matter to be listed, to be heard. And because of constraints, this is happening. So we have to work together and see how we can go about it. Anyway, next.
Deeply obliged.
Lordship, I wish to mention item number 15 of today's list. Addition
15.
Lordship, may be fixed after vacation.
Still one, permission.
First week of February also may be convenient.
Is it against conviction?
No, Lordship. It's regarding some payment of interim
Interim maintenance.
Payment of area maintenance.
area
Let
payment
it be in January. After Bihu.
after Bihu.
After Bihu.
A date may
Positive
be
time.
fixed, Your
Huh?
Lordship. A date may be fixed.
Huh?
Date may be fixed.
Yes. List in the interim paucity of time. List on. I'll give a date, no problem. 27/1. 27/1.
Obliged.
May I please, Lordship, I beg to mention item 16, my lord.
Yes.
As
this
in
matter
interim, my lord, interim may continue, my lord.
could not make up today
My lord.
because this was part heard, so I have to take it.
Item 16 not part happened. 16
No,
is
no,
not-
no, no, no,
Oh, my
earlier
God.
matter which I heard. So, when should we fix it?
Any date, my lord.
You talk to him, both of you. You can have, this is his matter.
No, 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 no.
Oh, not your matter. Which one? Can you repeat the
16,
number?
my lord, 1/6.
1/6 admission. Okay.
I am for the petitioner, C is for the respondent.
Any suggested date after vacation?
7, Your Lordship, 7 January.
7 January.
Then, my lord, after 20, my lord.
Will it be okay if I fix it after Bihu
My lord.
for you?
Okay, Your
Or-
Lordship.
19,
My lord.
19/1.
May I please, Your Lordship? I beg to mention item number 14 and 49. Kindly
14
date may be
14 and
14 and 49. Kindly date may be given.
49. 14 is, are they connected? They are not connected.
Not connected, Your Lordship.
First, let us do this. Acha, I forget. Item 14, paucity of time. Item 14. 9. Last week of January.
A date may be given, Your
A
Lordship.
date, I'll give you a date. Let it be on, okay, 27. Item 14 on 27. Okay.
27.
Item 49 on 29.
Your Lordship, I'm on interim.
Interim order may be extended. Which one? In which?
Uh,
In
item number 14.
14. Interim order extended. We'll check it also. And the other one?
Mm.
Hearing man. Okay, done.
Bless you.
Lordship, may I address tomorrow?
Sorry, we cannot take up your matter.
Lordship, I have nothing
No,
to,
it's okay.
Lordship, I
I had a
no
plan, but.
Lordship can kindly accommodate me tomorrow, Lordship. Because Lordship has given me enough chance. So if I complete my
Tomorrow,
reply,
yeah,
anytime to my Lord's convenience.
tomorrow we have a truncated day also. Because till 3:15.
Lordship,
But,
I
since
can,
it was fixed today, I'm finding it difficult to say no.
no, Lordship,
What time can we fix it? If we fix a time then, because tomorrow apart from other matters, our first objective tomorrow should be to complete the bails by 3:15 when the court has to rise because of reference. Reference has to be done. Former Chief Justice. Justice Gyani. Right. Huh? Up to 3:15. Up to 3:15. So. Hmm? Not seen the list also. Yeah. You will be starting a new matter. New matter.
No, sir, Lordship, I will be
He's rebutting.
Reply.
No.
Okay, at 2.
Tomorrow, my lord.
But you have to be, but will it be safe to have it on 2? Or should we take it up? I don't know. I'm confused actually. I'm finding it difficult, man. But I want to accommodate you also, but not knowing where to fit it in.
Lordship,
many
I will be
matters-
present
so
in
many
the court
matters
as
and
per
so-
Lord's convenience.
to, fit it. Oh, no, that can be done. On that day, that much, within that much, even if we don't say, sometimes may not be possible to finish, but for on that day, that much only will be taken. This thing is coming in our system. I'm telling you, this thing is coming. It is coming in our system. Plot system. It's coming. It may not be possible to finish the matter, but today half an hour I'm getting on. Because other matters are there. So if I fix it in the first half, can you suggest the time slot?
After finishing up of bail hearing matters, Lordship. Second. So at 2 p.m.
After finishing motions,
At 2 p.m. Lordship.
2 p.m.
That will be
2 p.m. 2 p.m.
Lordship, I will try to be as brief as I can.
Yes.
I will not take much.
Because we have a truncated day, I will try to go fast tomorrow. Finish as many as in the first half. But then some matters take time. No, we
Yes.
cannot decide a 37 matters just like that.
This takes the time. We can't fix
For
the
it-
time.
Huh?
We cannot fix the time.
What they have done in some jurisdictions is they're fixing a time because the thrust of the main argument is through the written argument. Oral argument is only for clarification.
Yes.
That's why they have fixed time. Otherwise, if the entire argument is oral,
Yes.
then it may not be possible. You
may
cannot
not be.
argue a criminal appeal in 15 minutes.
No.
Nowhere in the world it will be possible. The main thing is whatever I have to say, I put in the written.
Yes.
Then it's clarification. Then it's possible. But anyway, this is his reply, so he will be possible. You prepare it well,
So
and
far as 5:30 is concerned.
2:15 you finish. You
Lordship,
are already very thorough. You prepared very well. Petitioner in person. 2:15. 2 to 2:15 you finish.
Lordship, I beg indulgence. Lordship, 15 minutes it could be
Otherwise-
because the submissions have been
Otherwise,
for
the
hours.
other learned councils will be angry, not only at you but also at me. Because everybody was waiting. Definitely.